we go. Okay, good morning, everybody. 7 o'clock a.m. here. I know it's 10 o'clock Adam's time. And Travis, you're 2 hours different. So you're 9 o'clock, correct? Travis? I don't know. Why are you nervous, Candlin? Let's see. Travis, can you hear us? We heard him just fine
Yes,
before.
2 hours.
Yeah, hold on a second. Maybe Travis might have to go out and come back in. Let's see.
Yes, 2 hours. Can you hear me?
Oh, now I can hear you.
Yeah, there you go.
Okay. Yeah. So thank you, Travis, of course, for joining us today. You guys know in about less than an hour's time, 2 minutes before they will live stream, obviously, the Supreme Court there. So I just have this up, but really that's what we're waiting for is this. And it says it will start 2 minutes prior. But anyways, so up until then, I'll just show this. But thank you, Travis, for joining us today and coming on an hour earlier prior to the Supreme Court.
You're quite welcome. Maybe we can talk about some things, some questions from yesterday or building up over the week and see what we can get figured out and then give it a look, right?
Yeah, absolutely. So whatever you want to start talking about, Travis, and welcome all to the live people that are new here or not. Either way, regardless, thank you guys for joining the live stream. But anyways, yeah, where do you want to start, Travis?
I think Austin had something from yesterday. What was that? Austin about due process. No, something about that. What if the Supreme Court ordered a new hearing? Do you remember?
Do you remember that, Adam?
CJK asked it towards the end. Sonny said, well, maybe we can talk about that tomorrow. I think they were asking
about an evidentiary hearing. Was that it?
Yeah, it seemed to me maybe they were thinking the court might send it back for Judge Gull or some judge to conduct an evidentiary hearing on the gross negligence, or is that the way you took it? There was no actual hearing that Judge Gull had, evidentiary hearing to make findings of fact regarding gross negligence. She just declared it. And then somebody said that they had been reading somewhere that, somebody watched a YouTube channel and there was an attorney that said that was one of the possibilities. Sonny
Mark
said
Lopez, that's correct.
Okay.
Yeah. And I mean, sorry to catch y'all off guard, but did y'all have any thoughts on that? I really don't think that that's much of a possibility that they're going to send it back
down. That's
and say they wouldn't have done this. I think they could have handled that in the motion rather than do an order setting it for oral argument. They could have handled that with that order saying, we're ordering this sent back down for the judge to conduct an evidentiary hearing, and then the parties can come back if necessary, blah, blah, blah. I don't see much. But
he was just giving different options about what could happen. And that was one of them that, that perhaps it gets sent back down, that part to the, whatever you call it, the courts. Because I think, remember, they jumped gun, right? Wasn't it that they kind of went past? Well, there's certain kind of like rules how you kind of do things, and they kind of went whoop, right to the Supreme Court. Is that kind of what I think? I think that's what he was saying, that they could shoot that one back down and deal with it. Either way, he did a good video on it, just giving different thoughts about what might happen, but he didn't feel like the judge was going to get removed from the case. But he felt, I think, like perhaps that the old, because he is from Indiana, Mark Lopez, he felt like that there was a strong possibility that the old prosecution defense team might get put back on the case. So guess time will tell.
Yeah.
Yeah. I don't remember everything he said, but it was
Well, so yeah, all right. So here's the basic thing. People have narrowed this thing down to, 3 things can happen. Yeah, kind of, sort of. So number one is they've asked for 3 things. Doesn't necessarily mean they're going to get exactly that combination. Court could come up with something, and in fact, people should be listening to those types of questions during the argument. It's called oral argument. It's basically stand on your feet, think on your feet, and field questions that you've prepared for as best you can, and defend your position. And try your best not to concede anything, because the courts the justices will ask the litigants, the lawyers, to concede things if they can. Do you concede that this? But you want to be listening for questions about, hey, what are you asking us precisely to do here? Are you asking us to set a broad general standard for all cases on removal of court-appointed attorneys? Are you asking for specific facts and cases like this one? What is it that you're asking for? But anyway, so the 3 things that they asked happen in review. I'm sure everybody knows this. Is 1, reinstate Rozzi and Baldwin, because that's what Richard Allen wants. Number 2, remove Judge Gull for demonstrative bias. What she's done in the case up to this point shows clear bias. That's their position. So she should be removed. And then this, give us a trial date in 70 days per the rule. That 3rd thing, I'm just not even going to worry about. Like Aspen said last night, whichever one of them said it last night, Aspen or Adam, they, there's court rules on that, and if there's a new judge that's coming in, they can handle it, and so they can deal with the rule. So get them back on and have the new judge. And then people are talking about, they seem to focus a lot on, well, gosh, if they reinstate them but leave the judge on, how's that going to work? And
right.
I just the court may have a completely different solution to this, how it's going to work. And that's a lot about what the questioning is about. And so we need to be paying attention to that. The questions that they're asking each side is going to be very, very, very important.
So, go ahead. So what I wanted to ask you, Travis, is because when I first read, when this all came about, I was in my head, I had it that, okay, so that, the one side would speak for a half an hour and get out their reasons why they want, say, Fran Gall removed and the defense reinstated and the 70-day whatever. And the other thing I thought it was kind of like half an hour that the one side spews out, then the other half an hour, the other side spews out. But when Charmaine was talking, and I think you were in chat, so can you explain exactly how this process is going to go? Because I think it was that the one side starts. I think it was it the defense?
Richard Allen's side starts.
Yeah, starts, and then they can get interrupted, and in a sense, like how does
Okay.
Did you happen to bake a pie last night, Sonny? You have a pie sitting there, an apple pie that you can hold up? No? Okay. So picture a pie.
Yeah.
As a pie chart. There's 60 minutes. Each side gets 30. Now, the relators, Richard Allen, they get to open and close, start and finish, because they have the burden of proof. So they have to decide and let the clerk of the court know before the oral argument starts how many minutes they want for rebuttal for them when they come back at the end. And so let's say they say, we want 20 minutes of our 30 to argue, and we're going to reserve 10 for rebuttal. Okay? So then we got the issue of if they want, they can give amicus, which is that Indiana Public Defender Council, I believe, which filed a brief. But you know, their main issue to me, and it's been a long time since I've read it, and I didn't have time to go back over it. Their main issue was the way the judge appointed the two new attorneys wasn't part of their plan that they filed, and that would be a bad precedent if judge could put in the attorneys that they wanted, et cetera, et cetera. So it'll be interesting to see what, if any, time they give to amicus.
Right.
So it might be, we're going to do 20 on our side to start. 5 of that is going to be amicus. Then the respondents, which is the Attorney General and, of course, the court, they could divide up time. The AG could speak for 15 of their 30 minutes. So first, Richard Allen, his attorneys are going to speak for some period of time. Let's just say it's 20 minutes. They reserve 10 for rebuttal. Then the respondents, which is the court and the AG, filed a brief. One or both of them are going to argue and answer questions for 30 minutes. And then they'll come back. The Richard Allen, his attorney, is going to do rebuttal for 10 minutes. Typically, on rebuttal, there's less questions. What they're doing is writing down notes on the answers that the court, the attorney for the court gives. And, you know, if there's something they can pound on, they're going to pound on that. If they have a better answer to that, they're going to answer that. And they'll go back to individual justices that ask questions, and they'll say, Justice Rush, the chief judge, you asked opposing counsel, you know, is this necessary in order to decide this? And I disagree with my opponent. I think that the answer to that's a simple yes, pursuant to Jones v. Smith, you all decided 8 years ago, or something like that. And that's basically the flow. Everybody get that?
Yeah.
It would have been better if you had an apple pie.
Yeah. Or an eggnog pie. I don't know. But no, absolutely understood that completely. I hope you guys did as well. If you didn't, you can just put your question. If you guys have any question for Travis, by the way, right now before it starts, within like 40 minutes time type of thing, then just put it in the chat. And if he can help you out, he will, of course. But no, I understood that completely. Thank you. I think that made a lot more sense to me now in my head. Yeah. What about you, Adam? Adam, come on, speak. You're alive.
It made perfect sense to me. So I have a question for Travis. And this, I wasn't quite sure how to even like ask this because it's kind of twofold. Because one, I'm curious if the Supreme Court justices can use this as, you know, part of their questioning as why it wasn't an action that Richard Allen's attorneys might have taken before sending this up to the Supreme Court. Or two, if let's say the lawyers are reinstated and Gull stays on, is this an action they can still take tomorrow if they wanted to? And that's to file an interlocutory appeal.
I just can't see the court bumping up time from the normal 30 minutes that they have to divide, 15 minutes each, bumping it up to an hour, 30 minutes each, to ask questions about an interlocutory appeal. Okay. But it's possible. I just really don't think they have any problem whatsoever deciding this thing on the merits like they did with Jones v. Knox Superior Court. That's going to be a fundamental case, I think, cited by both sides. One says it shows that which was reached on the merits. It was a case. We'll talk about Knox in a minute. Did I answer that question? Let's
yes.
see if there's any questions, and then we'll talk about Jones v. Knox for a minute.
Well, really quickly, the second part of that was, so like let's say if Baldwin and Rosie, you know, get reinstated and Gull were to stay on as the judge, could they then just file an interlocutory appeal, you know, right away after that happens?
In order to have an interlocutory appeal, you have to have the trial court certify it and agree to it.
Okay.
Now, I guess they could kind of give a decision that tells the court, yeah, you better do this. But oh boy, I just really don't see it's in the cards. But you know, there were two major milestones in this case that occurred that we talked about before that people may remember, and one is that they even accepted it. They just didn't dismiss it outright. 99% of original actions just get summarily disposed of in short orders saying this doesn't qualify, we're dismissing your petition, and there's no appeal. They accepted it and ordered the other side, or allowed the other side, if they wanted, to file a brief by a certain date, which they did. And as a matter of fact, they asked for an extension, which on both, the other side agreed to. Well, they agreed to an extension on the first one, opposed the second one, but the court gave an extension anyway. And then the Attorney General came in and said, hey, wait, I thought you did an extension for them. That means an extension for us. Just to clarify, we have until that date to file a brief also, don't we? And they said yes. And so that was a major milestone. Then the next kind of thing was they got it all briefed, and we thought we were going to get a decision, because I went back and pulled up every original action in the Indiana Supreme Court from the one that was issued in Allen's case in December, all the way back to 2020. It's about 51 cases. They had oral argument in one case out of the 51. So they're very, very rare.
Yeah.
And it's very rare for them to have oral argument on it. And the fact that they wanted oral argument, that they expanded it, doubled the amount of time, whatever's been submitted by the parties is creating serious questions or concerns with some of the justices, at least some of the justices. So we got two major things there that tell us that this thing's going to be decided. And the first issue they have to grapple with is going to be whether the removal was proper. That's what the main focus is going to be.
Yeah. Travis, Charmaine has a question and Brown Skittle has a question for you, if you don't mind. Question: if the court rules in favor of the prosecution / goal, well, today, I know it's not going to happen today, but does that mean that RA can't appeal these 3 items again after trial if found guilty?
That's a really, really good question. So if they rule on the merits on that, as opposed to saying this is premature, you have a right of appeal, therefore it doesn't qualify. If they reach the merits, they're not going to be able to go back and appeal this after a trial, except that could potentially be an issue that if the Indiana Supreme Court didn't rule in their favor on it, they could take it to the U.S. Supreme Court under a federal issue. But they could appeal that. But it's real if they reach the merits and explain it, why it was a proper removal. And that may be why they wanted to have argument. They wanted to cut that off at the pass, but which is why a lot of this stuff's problematic in terms of what Gold did, not having a real hearing on it. We'll see. Are a lot of the questions to the attorney for the court centered around, well, yeah, she made these findings, but based on what? Really not much of a record here. So maybe that's what he's talking about. The attorney mentioned earlier that we want to, and that does happen all the time. We want to send this back for an evidentiary hearing for these facts, and then we'll consider it later. But nobody's going to be happy with that in terms of people who are following the case. It's going to be very frustrating.
And Charmaine says, I have a question, but it's hard for me to put into words. See if Travis can decipher this one. Can the Supreme Court rule in favor of certain points and deny others, or is it an all in or nothing? Read the, what is this? Decision for more info type thing. Do you understand what she's saying? She says, if not, I'll be more specific. What? I would think that we could approve some and deny others. Yeah, I would think. But do you understand what she's saying there? Or do you want her to re-ask the question?
Yeah, they can decide some and deny others. That's for certain true. But the three things that have been requested: reinstatement, removal, trial in 70 days.
I hear your doggies.
Yeah, if the court denies reinstatement, they're not going to get to 2 and 3. There's just no need. There's no need to remove the judge if the attorneys aren't back in, because that all hinges on the attorneys being reinstated, and now there's this situation of bias. I just don't see that at all, and that, of course, that's going to leave the trial date next October, November intact. And so, yeah, they can decide certain things and not others. But in this one, it's going to hinge on number one: are the attorneys going to be reinstated? And the Jones v. Knox case, that was a case. It's really interesting. Brian Jones, the relator, the defendant in that case, had 2 attorneys, and they were going to trial, getting ready to go to trial, just a few days before the trial was set, on a murder case that went unsolved for a year or so. It was a murder of a 19-year-old college student. Brian Jones went to the same college. They arrested him after they found another college student murdered, linked him to that, and then figured out he was responsible for the other one because his MO, both these women were murdered in their apartments. He did a little bit of cleaning up after the murder, which I believe was stabbing in both of them, and he left the bathtub running. And the second one that they could easily pin on him, the bathtub was running, and then somebody went, oh my gosh, that one that we never were able to solve a year or 2 ago, the bathtub was running the water on that one also. And they were able to go back and link things up. So the murders were in the late 90s. The trial was in 99, 2000 it was set for, and the state turned over DNA, new DNA results, very, very close to the time the trial was going to start. And the 2 defense attorneys filed a motion for continuance, which the judge denied. They then filed a motion for reconsideration and, denied. The judge just said, I'm going to exclude the DNA evidence. So they sent a motion to the judge with this. The motion started out with a fictitious letter to the client. Dear defendant so-and-so, your rights are being trampled on, and if the judge doesn't, we're sorry, but the judge has ruled this way. And, they were being cute, which you don't want to be cute with a judge, especially in a murder case. And the judge turned them into the bar for that, and then reconsidered the motion to continue, and granted the motion to continue. But as part of their motion, they also said, if you don't grant it, we withdraw. We're moving to withdraw. So the judge said, okay, fine, you want to be queued. I'm turning you both into the bar. I'm going to grant the, excuse me, I'm going to grant the motion to continue. I'm going to deny the motion to withdraw, but I'm removing you on my own, sua sponte. And they filed a writ exactly like this one, exactly. Petition for a writ saying you removed us improperly. And in Jones, the Indiana Supreme Court in 2000, and somebody's going to ask, none of the 5 justices in 2000 are on the court today. It's all new 5. So nobody from that court will be hearing this case. But they said, well, we don't, the removal of court-appointed counsel is disfavored. But we don't need to reach that because you all said you wanted to withdraw. And we don't see a difference between saying you'll withdraw if you don't get your way and the judge removing you because of this, because you asked for it on his own. So they said that's a distinction without a difference because you wanted to be in the position you're in right now, off the case. We're not going to decide it, and they denied the petition. It's strikingly similar to this case, and my view is this is what's going to be a lot of focus in the questions. How is this different? One side's going to be arguing, the court's going to be saying it's no different. It's no different at all. They both said in the in-camera hearing that they were going to withdraw. The judge took them at their word, and they're off. And the other side's going to say it's completely different. The judge put them in that position. They didn't put themselves in that position. In this case, they were coerced into doing that. And with regard to Rossi, he never said that he was moving to withdraw. He said he was going to file something in writing a few days later, and he did. And he said, hey, I'm staying on the case. So I think there's going to be a lot of argument about that. And, we'll see. But the court 4 years ago had a very, very similar issue, and they reached the merits on it. Now in Jones, they didn't ask for the recusal of the judge as part of their petition, so that's a new issue that they're going to have to grapple with. What are we seeing on the screen here?
These are from the Supreme Court this morning. A couple of them I got from Barbara McDonald. Someone else sent me a couple of the other ones. But there's Rosie and Baldwin waiting to go in. I think you can see. I think it was the other picture. You could kind of see Kara in the background there. No, not that. It was the other picture where they were in. Yeah, you can see her like that's her in the right there of Rosie.
Wow.
And there's Sunny's Facebook with her messages pulled up. Oh, and she's muted.
Oh. Wow, so the whole gang's down there, huh? Ready to go.
Yeah, and then I saw another picture that I guess there was still about 10 people waiting in line, and a lot of media. Sunny, do you know you're muted?
No, I didn't know I was muted. Thank you.
Oh, you're welcome.
Just quickly, just because I see this, and I'll bring that back up. I accidentally hit the wrong thing, clicked it off, and of course I ends up showing my Facebook, but that's the best way I was showing those pictures instead of going down and up and down and up. But anyways, Travis, taking into consideration all the leaks that happened from Baldwin and Rosie, mainly Baldwin's office, are there any grounds for being disbarred? That's by CJ.
No. You know, it's the remedy for violating a court order is contempt. You know, and the other remedy is, you know, violating the rule. It could be turned into the bar, and for violating the rule on pretrial publicity that, you know, every state, they pretty much adopt the model rules, and there's a rule on what you're allowed to say or not say. It's very gray. It's not too specific, but you know, the wouldn't be disbarment. You know, it's that level. It'd be a reprimand probably, but not disbarment. But it could trigger a discipline. Could trigger a suspension. I really don't think so. That's my answer on that.
Okay. Sorry, I just need to go back to this. It will be in they said 2 minutes that they'll be starting the Supreme Court. Adam's biggest fear is that they're not going to be able to handle the overload, and that the Supreme Court site will crash.
Remember when they created the website that's now, you know, been very controversial as far as, you know, with the 138 or however many documents that were on at 58, I can't remember now. And of course, like immediately it crashed. So I'm just hoping that someone from the IT department, you know, anticipated the bandwidth that the website was going to probably need to handle the traffic it's going to get for this live stream. Because I think that's just going to be a mess if all of a sudden, you know, it starts and 20 seconds later the whole system just shuts down.
Whoops, sorry. Oh, I see what's happening there. So, okay, CJK, sorry. Frank is, I guess, there, but he has other people like Ruckus and that, I think. No, not Ruckus. Yeah, Ruckus and Coach Cav and somebody else, Kristen, on his channel hosting.
Okay.
Gotcha. Okay. I never actually looked.
I saw a couple of people that, you know, like had shown like their lottery number, like, because I guess they did like a lottery of who gets in. So it'll be interesting to, I think they said, were they opening the doors for 10:45 for everyone?
Well, you had to buy tickets, I know, really early. It was like
well, not buy tickets, but you know what I mean. Yeah.
Yeah. I don't know. CGK says Frank was first in line. It's now first come, first serve. First in.
Okay.
Frank.
I heard the media presence was a lot bigger than like just the people trying to get in.
Yeah. Wow. Well, that was smart of Frank to do that.
There's definitely a lot of people on Twitter and stuff with it already.
Deb just said it was first come, first serve. No lottery. Doors opened at 10:30.
Okay. Oh, it's funny. I saw people with their ticket numbers, which is funny. So, I mean, maybe they were handing them out, anticipating more people coming, and then they just did first come, first serve.
Yeah.
Because I got a picture of someone that said like number 4, number 5, number 6.
Oh, don't know. Anyways, is there anything else you want to touch on, Travis? We got about, I don't know, what, 42, like 18 minutes before.
The only other thing I wanted to touch on is there was another case from the mid-60s where a judge, 2 employees, county employees, had sued the county for salary that they hadn't been paid. they didn't detail what the dispute was about and why the county wasn't paying these people, but they appointed a special judge. Special judge comes in and he orders the entire county council commission to come in, the 5 commissioners, and be there for a hearing. Starts to hold this hearing, and he promptly orders 3 of the commissioners to be held in contempt. And then the county attorney starts to talk, and he holds that attorney in contempt. Then an attorney comes in to speak for the county attorney, and he orders that attorney removed from the courtroom. Then he holds the county auditor in contempt, and he orders the sheriffs to hold these 5 people until the auditor goes down to his office and cuts 2 checks to pay these employees, which he does. Gave him 10 minutes, I think. Then he said, okay, now, sheriff, take these 2 employees with their checks down to the bank so they can cash them. You other sheriffs, you hold these 5 people till they come back and confirm that the checks are cashed. I mean, it's just crazy. He's throwing people in contempt left and right. And long story short, all of that happens, and then he grants the dismissal of the 2 lawsuits by the county employees for their salary, which he was trying to moot the original action petition for mandamus. And they file the petition and get it all in, and they immediately remove that judge from the case. The judge, someone made a request in trying to prepare the petition and have a record, requested the transcript of the hearing. This should sound familiar. And the judge ordered the clerk not to prepare a record and a transcript until it's what we call the contempt, people held in contempt, the 5 county officials, purge their contempt, which means simply means that the court would order whatever the penalty is, fines or whatnot, and they're paid. But you said, ordered the clerk, you're not going to prepare a transcript. And I bring up this case just to show that, the court the Indiana Supreme Court had very scathing comments. They talked about the attempt to not allow the litigants to prepare a proper record, continuing the evil, I believe was the phrase that they did. And they ended up removing that judge, appointing a new one, and they appointed the new judge. And then they said on the reinstatement, and this is the very important thing to remember here, and they've done this in other cases more recently. They've said the orders of the trial court judge to date, the new judge can go in and reconsider any orders that have been issued in the case. So if they ordered the judge to be removed, in this case, our case, that judge very likely could go back and reconsider any motions going all the way back to the beginning. Now, they may not request that, but the safekeeping order, the order, the protective order, all of that can happen. Why don't you read that? What's going on here?
Oh, it just says Judge Gull will not be attending today's Supreme Court oral argument. She's presiding over a trial in Fort Wayne. Richard Allen's attorneys are asking the Supreme Court to replace Gull with another special judge. They say she is, basically.
Okay. Okay, they're just announcing
Yeah, they're just letting
Judge Gull's not going to be there. I wouldn't expect her to be there anyway.
Yeah.
It's just very, very rare to have the actual litigants in the courtroom. In the U.S. Supreme Court, criminal defendants are never there. I saw, Sonny addressed that. Sonny and Aspen addressed that, I think, last night, that there is a right apparently in Indiana for the criminal defendant to appear in the Indiana Supreme Court. Haven't seen the rule on that. I've never seen any state Supreme Court allow a criminal defendant to be present for oral arguments ever. But
right.
The way they did the press release, was that Kara? The way I read it, that it sounded like they had a right also, that they'd been contacted about security and whatnot, but he's clearly not going to be there, and I didn't expect Gull to be there at all. So apparently she's back from whatever health issue, and she's presiding over a trial, and it's moving forward. So presumably she's going to be moving to do something on the new motion that the new attorneys filed about the conditions under which Richard Allen's in prison with that guard, and not being able to have effective attorney-client communications with Richard Allen. That part of it's very, very troubling. But they are going to be limited to the record that's before them, and neither side apparently supplemented the record with that motion, so they're not going to be able to go into that. And if they tried, one of the justices would say, well, where is that in the record? And they're not going to be able to point into anything in the record, and they'll get chewed out a little bit about that. But if a justice asks you a question, so attorneys for the court, they say, well, one of her findings was that they weren't truthful. Didn't the new counsel just file a new motion with the trial court, saying the same thing? And that attorney is going to have to answer it. You can't say, well, Judge, that's not in the record. Well, yes, Your Honor, but, disagree. It's different set of circumstances, what the judge felt, the attorneys were being untruthful about, and then, try and mire then come back to Richard Allen's attorney and say, well, don't we really need to send this back? Don't we have a problem here on these findings? And then the answer would be no, because even if these things were true, they're not grounds for removal under Indiana precedent. So the justices will be kind of playing games, not games. it's very strategic. It's very logical. It's, you know, you have to be very careful what you say as an attorney in an appellate court argument. You know, again, that goes back to conceding issues. Well, don't you concede that there really needs to be more fact-finding for us to be able to make a good decision in this case? And you have to be very careful if you concede that ends up what happens, that it gets sent back for an evidentiary hearing where they have a full-blown hearing, which
Right.
if they did that, they're in effect reinstating the attorneys for the purpose of that.
So
Can't send it back for an evidentiary hearing on two attorneys who are removed. You know, there's no legal issue there. It's
right.
They would say, okay, we're going to reinstate you for the purposes of the judge having a full-blown evidentiary hearing. The judge will decide, and if we need to go further, we'll go further.
Okay. Charmaine saying, word on the street is that Bob got in. You know, definitely a monumental day, isn't it, Travis?
Yeah, I have a text from one of them saying he got in. So,
oh, okay.
Good. Yeah.
Yeah. Yeah. Like I said, everyone and the dog is on live right now for this Supreme Court thing. It's like I said, everyone's, you know, looking forward to it. We got like 4 more minutes, and they should, I mean, according to what they're saying, they stream 2 minutes before the live is when it will go. So we're almost there. We're almost there to see this, and excited, eh? Yeah, I bet you there's a ton of lawyers in that are watching this case, like, because of again, if this, you know, sets precedents or not, or whatever, you know, ends up coming down with this all. Be very interesting to watch this whole process as they're doing this live for sure. Oops. Adam had just sent me well, because we got a couple minutes. Actually, I'll 1 second here. You still there, Travis? Travis? Oh, he's muted. Travis. Hey, Travis, do you know you're muted? He's probably does. But anyways, Adam, did you have your smoke? Are you back? What am I doing?
What are you doing?
Well, I was waiting for you to answer me, but
it cut out. What was your question?
Oh, I was just saying. I think I was saying, are you excited? Like that there's a bunch of probably other lawyers watching this case and stuff like that, because, you know, this is going to be a very interesting watch for a lot of people today, for sure. And it's just a couple minutes before it's supposed to actually start live streaming.
Does it appear that people are able to tweet from inside the courtroom? I'd be very surprised at that.
Adam, I know you're at your computer. What?
I'm back. Sorry.
Can people tweet?
I'm not sure.
One sec. Okay, that was just a little bit of video that Adam sent me of the commotion going on at the Supreme Court there.
Hey, look, 1 minute till it should go live.
Yeah. Let me just. Well, I'm not sure if this can like how it goes. If it goes full screen, either way will.
It does.
It does. Good.
I think so. Yeah.
Okay, so we're gonna hide that, and then we'll make this full screen here, I suppose, eh?
Yeah. And the only thing I've heard that's came out of Mitch Westerman's hearing this morning is that they've set they're going to set a jury trial date for about a month or two from now, but I've heard nothing specific.
Okay. Oh, for Mitch Westerman, about a month from now, did you say? Okay.
I wonder if you have to refresh that or if it just will start by
No,
itself.
it will just start by itself. It's already been refreshed today, but
Their 2 minutes is up.
yeah, I mean, I'll refresh it, but oh, here we
Oh,
go.
there we go.
Okay. Well, they were correct on their time. AJ, where are you? For my 2-minute countdown there. All right. Everyone excited to watch this? I know I am.
Yes.
Yep.
I just pray that the stream holds out.
Yeah. You don't jinx it. Don't jinx it there, Adam.
I'm not jinxing it.
Aspen, do you think we're actually gonna get to see court on time today?
This is the first time I've watched a live Indiana Supreme Court, so I don't know.
Yeah.
I would assume that they should be pretty prompt.
Yeah.
Okay, so what's the prediction on how long they're going to argue initially? 20 minutes and 10 for rebuttal?
Yeah.
That's common. 50-50, 15, and then 15 in rebuttal. That's rarer. Some only 5 minutes on rebuttal. The hard part is you have to decide before you start, and then
Right.
it's kind of like, oh man, I wish I would have saved more time for rebuttal. But this is a very seasoned lawyer.
Look, right on time.
Yeah.
Come in order. There's the chief judge, Judge Rush.
Yeah.
And the other justices.
Nice.
One lady, 4 men.
Oh. Okay, let's turn this up full volume here.
Good morning and welcome.
See you guys on either side.
We're here this morning to argue in the case of State ex rel. Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. Gull, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes, so you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that You
have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Bolden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action, the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
because you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth Amendment
my concern is
requires.
getting this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're not
filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that yet, just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance of counsel.
But even if it did?
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear. Nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So your solution, why you think that counsel's, Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed? So, which means
Well, we
We
won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you
and
help me
attorney work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys, and so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, I mean, in the Wheat case.
Wheat
I don't
himself,
see Wheat as tucked as neatly as you find Wheat. So
Wheat
go outside Wheat and give me something else.
well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, you know, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me
Wouldn't
offer
that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr.
Your Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What would be the harm if
because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out, and there'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there. If someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So of course none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular things cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance with counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel. I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The attorney general and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would, even if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise, the ineffective assistance of counsel and justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right. Ladies and gentlemen, this courtroom will be exited in a voting fashion. Start with the first 3 rows on either side of the courtroom.
Okay. Well, and Ivy's going to be joining us in a second here as well. Let's see here. Well. there's a lot that was said. I was very interesting. I want to say that. It was a very interesting watch. I'm so glad we got to be part of that.
Absolutely.
Yeah, everybody stand. Yeah, everybody. But anyways, yeah. So I really have to go to the bathroom. I was just holding off until we got to this point because I wanted to hear everything. I said Ivy will be joining us in a minute, but you guys go ahead for a minute and I'll be right back. I can still kind of hear you because the bathroom's not too far away. But anyways, whoever wants to speak first, go right ahead.
Travis, are you there?
He's on mute.
Well, I mean, I thought that, it was like, wow. I mean, I'll have to digest all of that. I think my overall takeaway from what I watched was that regardless of the court's decision, I don't think anyone will be able to argue that the court was not fair, and I think showed that they really want this to move along, and I think that they gave both sides very fair questions, and it made very good points. So I think whatever their decision is going to be very hard for people to really argue any bias towards.
Yeah, something else. It was really good for everybody to be able to see that, and the questions being asked. And my takeaway is that the reason they wanted oral argument is they're troubled about a lot of things that happened at the trial court level and the way this thing proceeded. And the first thing they're grappling with is, like we predicted before, when, if ever, is it proper for judge to remove court-appointed counsel? And then we heard conflict, we heard ineffective, and as predicted, ethical violations. I think, none of the 5 members of the court feel it's proper to remove somebody for ethical violations. They're putting, the court's counsel is putting all of their eggs in the wheat basket. We heard the other side's response to that. They figured out in between opening argument and rebuttal that they better concede that. Otherwise, they could end up with a decision where they send it back for further fact finding. That was on the issue, can he waive ineffective assistance of counsel up through October 31st? And that was the second point he covered. He was obviously, the state and the who took a more neutral position in the court, Gull's attorney, they took a pounding by characterizing Richard Allen's desires for counsel. We don't know, where it's unclear. And he starts with that letter, which is absolutely clear. I think that was more for the benefit of, I guess it's literally the world that's watching that closing those oral arguments. But they're really grasping with, the court, I feel, collectively is grasping with, well, judges need to have control of their courtroom. They need to have control of pretrial orders, protective orders. They need to be able to have control of that. And how do they resolve this? To use the Chief Justice's words, how do they get the case back on track, unquote, with this two competing interests? The interest of having the court being able to run the courtroom and have orders complied with, how that intersects and competes with the selection of counsel. That's kind of my take on it. The very, very probing questions. I agree with Adam. Justices were very, very well prepared. And, I saw some comments that, some of these justices may have already made up their mind. They do, in fact, they've pretty much made up their mind. When they order oral argument, they're 95% there, but the whole reason for oral argument is that they have questions, and there are some things, they're trying to sort out. They're getting assistance from the attorneys on answering these questions and bringing them to the forefront. I feel that the Chief Justice was really struggling with what happened down below, but she could come up with something completely different. You can't absolutely predict, but you can get a good idea. But
right,
that's kind of how I see things.
I have a quick question, and I want to welcome Ivy to the stream really quickly. Hey, Ivy.
Hello, how are you guys?
Good. How are you?
Good. Excited.
I just have a quick question for Travis. Well, two actually, but one was the thing overall that I did not hear. I felt like I heard very little discussion of it at all, if any. Was any really questioning that Gull should be removed?
That's a very astute point. I wrote down in my notes that no questions about removal. I don't think that's on the table the way I see it. If they're going to reach the merits on reinstatement. My take on it, biased, could be completely wrong, is there's a better than 50-50 chance that they will be reinstated, but I don't, clearly the number 3, the 70-day rule is, I think, off the table based on the questions and the answers about the trial. But I don't really think they're going to get to that. I think, if they do reinstate, they're going to say, you filed a motion for recusal. If you still want to proceed with that, go ahead.
Right. But I mean, technically, if they get reinstated, they can request the 70-day, time clock for a trial to start that day. So to me, that's never really been a strong, something I'm really even concerned about with this case. But I just didn't hear anyone talk about Gull being removed, and I found that interesting. But the other thing I thought was would it be uncommon, because I was just looking to see if there was any footage of people leaving court and stuff, and would it be improper or uncommon that Baldwin or Rosie would give any remarks publicly leaving court today?
It would not be
look
improper.
for?
It would not be improper to give generic comments. It happens at the U.S. Supreme Court all the time. They come down those majestic steps, both sides, and one side says, we were very pleased with the questioning, we think, we got our points across and they were received very well. Both, it's like spinning after a debate, right? Although in a much more reserved, thoughtful way. Certainly no comments about any of the justices or their predictions. They wouldn't, that would be improper, but to talk about how they felt about it, and even more specifically, the attorneys that argued can comment about how it went, but not getting into the merits. You know what I'm talking about? So if watched a movie, you could talk about overall, thought it was a very good movie. The directing's good. The cinematography was fantastic, but you can't be talking about how particular actors performed or that sort of thing. But it would be proper. I was reading some of the comments Ivy had in the chat, and I was wondering if we could ask her about what her overall view of this was.
You can't. I loved it in general. And I agree with both of you guys that I heard, and obviously I'm not trained in law or anything, but just from everything I've read and witnessed and researched, I felt like both sides got their arguments out, the arguments that were appropriate for each side, and also that by the questions that the judges asked, they obviously understood the arguments that were being made. So I feel like even if people don't get the answer they want, you can't argue that all the information wasn't out there. Like they understood it, and even if it comes out and the relators lose, I don't think that they should, but if they do lose, at least I know that the judges were open and unbiased and understood the arguments that I, as like a little person of the public, thought that were there. So that makes me feel good. My favorite part was when one of the judges said, there's a difference between insubordinate and ineffective. And I feel like that is, those 3 words could be like a description for the entire case almost. Because I do think that if anything, they were insubordinate, but I don't see that as ineffective. And I did write something down about the same thing that Adam was talking about. And basically, so would like win.
I
And
think
they, what?
I think you cut out a little bit.
Oh, let's say the realtors win.
You're,
Can you hear me?
yeah.
Yeah.
Yeah, and Sonny, you're muted, by the way.
Oh.
Let's say the realtors win and they reinstate the attorneys, but keep Gull. So, and then as the judges say, like, go about it the right way to get them kicked off or do the hearing or whatever. Does that mean that Gull would be presiding over whether or not they were in the wrong and could be kicked off if she went through the correct steps? And also, would she be the one presiding over getting her removed from the case if they went along with that?
Well, from a legal standpoint, and the questions, that certainly could be the ruling that judge, you didn't have a hearing and your findings are proper, insubordinate. We don't think wheat applies, as you pointed out in the chat, Ivy, that a possibility of being ineffective is enough. Wheat is distinguishable from this case. It was regarding conflicts, not ineffective.
I'm glad you said that. I forgot about that part.
I wrote it down. Anyway, so I really don't think they're going to send it back down and say, Judge, you can have a hearing about whether they were ineffective. I think they're going to, if they get reinstated, it's going to get sent back down. But what would be open would be they filed a motion to recuse, and those are typically heard by a different judge to determine whether there's bias or not. If they did send it back and said, there wasn't enough here, we're reinstating them, obviously this doesn't preclude the court from having future determinations or determinations about what's occurred up to this point. That would be heard by Gull. Did that answer your question?
Yes. And you reminded me of the two things that I wanted to hit on, actually. The first was the conflict of interest. From my understanding, they said the reason that conflict of interest is different is because the conflict in itself let's see how I word this. The conflict in itself is an opportunity for that attorney to have an incentive to do wrong by their client because they're gaining something with their conflict of interest, basically. So it's different than another like misconduct type of situation. Is that correct?
Well, and this gets back to the, words being used interchangeably, insubordinate, ineffective. So with a conflict of interest, which can be waived, they talked about that in writing. The reason why conflicts are a problem, and they use the sleeping with a client analogy, they need to get on the record that the client who's sleeping with his or her attorney understands the problems, and that they're doing that knowingly and voluntarily, and they're waiving any argument about that later on. I think, Ivy, really the point is that, and what we'll need to see the court, what they come up with, the relators made the point this isn't a conflict case, pure and simple. So therefore, wheat is of no value. And he covered that in rebuttal rather well, read right from the opinion. And that goes back to then don't you have to be ineffective? And so I don't think conflict's going to come up much in their decision. I could be wrong about that because there is no conflict here. There's only one client. So the way you have conflicts is you try and represent two defendants in a criminal case, which is highly frowned upon, but it can be done with the proper waiver. Because you end up with problems in trial that you're, based on the theory of the defense, that you're favoring one defendant over the other. It's almost impossible. And so they just don't even like it from the get-go. The other is conflict representing a family member, representing someone that you're in a relationship with. That's the other big area of conflicts, and none of those are, implicated here. So I really don't think that's going to be much of a issue on it. The reason why it came up so much is that one side was using cases that were conflict cases, and then there's a dearth, a total absence of cases where a court has removed counsel of choice. And he was very careful to say the entire team. So I assume there's some cases around the country where they only removed one attorney, which implies that they'd be okay if it was just Rozzi being reinstated. But, so you have one side where they found cases, but they involve conflict. And then the other side has no cases. And that's how they started out the argument. No case in Indiana has removed court-appointed attorneys desired by the defendant. There's just no cases. And so that's the way the arguments flow. And it's like Adam mentioned this 70-day.
Travis, you cut out there if you don't know it.
Did we lose him?
Can you hear me now?
Yeah, I can hear you now.
So the 70-day issue number 3, that was put in there belatedly, and they talked about it a little bit. Well, he signed it in August. You didn't file it until October 31st or beginning of. They put that in there so that they would be able to argue certain things today, that the judge was interfering with strategy, that they had caught the prosecution flat-footed, and they wanted to proceed to trial beginning of the year, whatever it was set for. And it's a throwaway, but you try and put some stuff in there if you can, so you can argue it today. I was caught flat-footed when the Chief Justice said, well, it's in the record in the other case, new filings that, the same things persisting, with the being able to interview. It's a new motion to transfer because of the problems. And they reached down into the trial court into the filing last week. So they're obviously aware of it. And then another justice, I can't remember who, kind of referred to it, not that specifically, but offhandedly. They're aware of it, and that's factoring in for them. And as everybody here has talked about previously, that filing, which tells me it was by design, the timing of it, that filing undermined Significantly, one of the reasons Gull cited for the removal, that, you know, what they were saying about Odenist and Odenist wearing patches, you know, this stuff wasn't true, and so on and so forth. That was, you know, one of the three main things for the rationale for removing them. The new motion that was filed last week significantly undermined that. But I just thought it was really interesting. They didn't need a supplementing of the record. They, you know, they're obviously reading everything real time. I thought that was,
I was surprised
that
about
kind of
that too. Before we get too far away from the speedy trial, I have one question about that, and kind of going off what Aspen said, or at least how I understood what he said. I'm pretty sure I understand what you were saying about they they put it in there to argue today, but the way I understand it is once you schedule a trial out, so how Alan's current attorneys did, they scheduled it out to like November 2024 or something like that, and then the prosecution said, basically, are we putting this on the defense? So doesn't that make it where you can't use a speedy trial up until that date?
That's a great question. So yeah, what on the speedy trial statute in Indiana, it's Rule 4 of the trial rules, and specifically 4C, I believe. They look at, you have, if the defendant insists upon it, they have X number of days to hold the trial. Let's just say that's 1 year, for example. It's 1 year plus any time that was added due to the defendant. So if the defendant filed a certain type of motion and it took 45 days to get that resolved, that 45 days would be added to the 1 year. So it would be 1 year and 45 days.
So that's
so
why
they wanted to
charge it to the defense.
That's why they want to charge the time to the defendant. And I don't know the answer how it would work if they're reinstated. I think the time between October, you know, when this stuff started, and now would get added. So if they decided by, let's say, February 1, that time would need to be added and would be charged to the defendant. So you'd be looking at a summer trial.
Because to me, Gull removes them, so then they have to have new defense attorneys. There's no way those people can get caught up on a case, you know, in a few weeks. So even though they had to motion for that, it's, in a way, not officially, but like unofficially, it's actually the fault of the state that the trial isn't going to happen, yet the prosecution wants it charged to them. So it's kind of like they were in a no-win situation. And even if the defense wasn't planning on doing the speedy trial, the way that happened makes it a better argument in my mind, because it did mess it up. So it makes it look like they really were trying to undermine their strategy.
Precisely. And that goes to Adam's point about, you know, doesn't look like they're even going to get into that if they do decide to reinstate. And that was put in strictly to be able to argue strategy today, is why they did it. They knew they didn't file it. They knew they were going to have to concede. The justices, the Chief Justice, was clearly on top of that
Mhm.
with the question of him, well, your client signed it in August, didn't he? Yes, Your Honor. And then essentially paraphrasing the response of Relators Counsel was, but there was no reason for them to file it until then. And then the response from one of the justices was, well, was he prevented from filing it? I think. Maybe I just kind of implied that. No, there was no reason not to, but that was their strategy. And the only way they could get that in the record was to do what they did in the trial court by filing it after the fact. And that's the best they could do with the record. And I'm sure when they were preparing the brief, they said, well, they're interfering with strategy. Okay, well, we got a cite to the record on that. Where do we have that? Oh, shoot. Well, we don't. Okay, well, what can we do? Well, was there the notice of speedy trial request, whatever they call that document? Well, we have one that was signed by him, but we never filed it. Well, let's do it, and we'll do the best we can. That makes sense?
Yeah, sorry. I couldn't find my mute button.
It's okay.
I think Ivy was too busy gushing at all the comments about her in
No,
the
I had in the middle of
chat.
that explanation, my dog got out of the yard and was barking at somebody walking.
Oh, well, I answered your question perfectly. Just rewind.
I got most of it.
Hey, Travis, just quickly. So Charmaine had said that, Defense Diaries over there said that it will be in Miss Defense Diaries, Allie. So there's no question that defense will be reinstated. Unsure on what they will do with Gull is interesting. And then she says, and that's what I was kind of wondering too. Allie's experience, her judgment isn't off base in my opinion. But if they grant full relief, then Gull is gone. Is that be correct?
Well, yeah, because full relief is reinstatement, removal of Gull, and
Right.
a trial date in 70 days. But what you just said before that they
Yes.
feel, and I do too. I said it before just a few minutes ago. To me, it looks like all 5 justices had serious concerns about the way Gull did this was proper. I kept hearing proper. If we do, so if we send it back and it's done the proper way, I wrote, it was like 5 times I heard questions with proper, which means they feel that what Gull did, maybe not the same things among the 5 justices, but there was some impropriety in the way this thing went down. And so they reinstate him, I think, based on the questions and the fact that they even, like we said before, the oral argument even started, the fact that they ordered oral argument told me that there was a significant chance that something was going to be ruled upon in favor of relators. I thought that judge on the far right with the beard who soft-spoken. I thought at first he was really hung up on the technicalities of original actions, but his later questions didn't seem so much that way. But, I think there's a better than 50-50 chance that they're going to be reinstated. And then I agree, you cannot tell. I think number 3 is completely out of the question. If they reinstate them and if they remove Gull, they're going to say, move forward with your trial with the new judge.
and, proceed according to the rules, and whatever time is charged to you is charged to you. And you'll get your trial according to the rules and the timetables. But so the big question is, what are they going to do on goal? And I just did not get a sense whatsoever that they were going to dig into that issue if they grant relief on number one.
Okay.
Skip. One thing I found interesting was that, and it's something I hadn't really even thought about too much, was I liked that the one justice actually brought up the whole, are you asking, that they be reinstated as public defenders, or, what if we decided they can be reinstated, but they have to be pro bono or paid? I thought that was an interesting part of this that I really hadn't thought about too much. Is that, what if they do come back and say, Rosie and Baldwin, have the right to be Richard Allen's attorneys again, but that, it's got to be either on their own dime or on Richard Allen's dime.
Yeah. So.
And you heard the response of Relators Counsel on that.
He was like, we don't want to pay for it.
It was, if you find that they're entitled to reinstatement, don't reward the bad conduct of the state, the AG, and goal by making them do it for free. But they did that in case the argument shifted to, well, look, under the law, a court-appointed counsel, she has the right to remove them. If they were private counsel, she wouldn't be able to do it. So they went ahead, and that was strategized, obviously, between the 19th and the 31st when they offered to do that. And then what Relators Counsel said, look, that's in there so that if the standard is different for removing private counsel than it is court-appointed counsel, they should still be reinstated, and it's on their dime. But then he said, he basically said, we did that for strategic reasons, but you really shouldn't reward improper conduct by the judge, assuming they find that, by making them do it for free.
Yeah.
Let's see. Skittle had a question just before this. It was a really good one. Can we go back to that?
Yeah. Right there.
Is it possible Supreme Court might come back and ask state for the exact list of reasons? It wouldn't be done in that way, Brown, Skittle. It would be that we're sending it back for a full evidentiary hearing on ineffectiveness. I think that's pretty clear that that's what they were struggling with, that ethical violations, which weren't argued as ethical violations by the court in her list, they abandoned 2 of the reasons and went down from 5 to 3. That was all of the questions and discussion and answers, responses about improper versus ethical versus conflict versus ineffective. And my take on it is if they were ineffective, she had the right, absolute right to remove them. The court's attorney referred to Wheat, saying the possibility of ineffectiveness, and then we went to, well, that's a case about conflict, and where you have a conflict, you do have the potential for an attorney being ineffective right from the get-go, just by the nature of a conflict. This is not a conflict case. Nothing about leaking materials had anything to do with ineffectiveness was the argument of the relators. But so hope that answered that question. And then you had another question by right after that popped up. Was it from Chiwerty? Was a question after that, Sunny? How did they get away from not even addressing goal? Adam or Ivy, you want to take that one?
How did
almost
how did they?
can.
Well, I mean, Travis, I mean, we're not lawyers, but I mean, I found that to be a glaring omission in the entire thing, is that other than a brief mention by Mark Lehman in the beginning, there really was no discussion of, why Gull should be removed from the case. It could be argued that, that when they were arguing the merits of Baldwin and Rosie's dismissal, that could be construed as, also reflecting why Gull should or should not be there. But I just didn't hear any strong argument on either side. I just feel like it was not addressed that, that Gull would be removed. Same with the 70-day thing.
Yeah. So this is where, personally, not being a lawyer, and just because it's bugging me. So if they're reinstated, and I know you probably already said this, you guys, Travis, if they're reinstated, what happens with Gull?
Well,
we
don't know. If the decision is they're reinstated and Gull is removed, it's clear. They'll appoint another attorney. If they just say they're reinstated for this reason, it'll depend on the reasoning for the reinstatement. If it leaves wiggle room for the judge to have another hearing, then she may have another hearing. If it doesn't really leave any room, if it says the reasons cited by the court in the in-camera hearing in her brief can never be grounds for removal, she's not going to have another hearing, and then it will proceed forward, except right now, today, there's a pending motion for recusal based on bias, which they could urge, we want to go forward with that, appoint another judge, and we're going to make our arguments. And that happens. And then a lot of times they say, we disagree, and then you go forward with the trial, and it's not as uncomfortable or awkward, or I've heard different terms, as people think it might be, depending on what's said about the judge in the hearing and whatnot. But what's been filed to date in the recusal motion, there's nothing, if it got denied, that they'd be able to go forward and have a trial, and everything would be okay. But that's what's going to happen if they grant number one. But they may just say, based on our decision on number one, we don't need to get into issue 2 and issue 3. And then it would go forward.
Just quickly, Ivy, just 1 second there, and then I'll let you go in. But as for Waick, honestly, you're best just to go back to the part of the live with the Supreme Court to listen to it all, to get caught up on what we're talking about now. So there's no decision that's been made today. We're just talking about what was in the hearing, and there's too much that was said. So it's just probably best that you actually go listen to that yourself, so that you can follow along to this part of it and understand kind of what we're talking about, because we're really just talking about what happened in that Supreme Court hearing today. So sorry, Ivy. So okay, Waick. Anyways, go ahead, Ivy.
I wish I had the reasons. Sorry about the squeaking. The reasons Gull gave to remove them. I guess I'm just going to go off my memory. I'm reading Brown Skittles' comment. I hope Baldwin and Rosie at least get some kind of ethical violation / strike. Not sure if that's possible, but what they did was so wrong and shouldn't be rewarded. I feel like I have an unpopular opinion about this. Obviously, I'm a therapist, so confidentiality is very important. It's a huge thing to break, and we have, standard rules in place, like information has to be behind like 2 locks and things like that. I assume in law it's similar, but Baldwin's office, obviously, I think part of it was because of the way he runs his office in general, being collaborative, but whatever they were doing wasn't right because somebody was able to go in and get pictures. Without evidence that he purposefully put that through, and I know there's a lot of, I hate to say emotion, I'm almost backtracking on even bringing my opinion into this.
It's all good.
There's a lot of emotion in because it's crime scene photos, but if you remove the crime scene photo part of it and just look at it as a piece of discovery, it was a wrongdoing, but I wouldn't, maybe Travis can speak on this. I don't think I would put it as at the top of the list of possible misconduct, if that makes sense.
Yeah, so I'm glad you mentioned that aspect of it. One of the 5 reasons was that it was apparent and it was discussed that Baldwin was collaborating with another lawyer about strategy in the case. And there was a lot of comments leading up to that. Oh, well, that's horrible, that's bad. And we don't have specific rules about how to lock up files or how to keep confidentiality secure. Most of us get all of our employees to sign confidentiality agreements and things of that nature. And, it's assumed that attorneys are going to have common sense. They don't leave files hanging around, that things are locked up and secure from outsiders, that sort of thing, but nothing specific about, it shall be in a locked cabinet, things like that. But collaboration, when therapists get licensed, they usually have to work under the supervision of a licensed therapist or psychologist for so many hours before they get fully licensed. And so you have obviously a professional who's going to be licensed working under someone who is licensed. They're collaborating all of the time. As attorneys, we don't do that. You sit and pass the bar, but defense attorneys in all kinds of cases kick around things. Therapists, I'm sure I have a patient.
Yes.
And they've got this going on, and what are my duties of reporting? Do I have a duty to report in that situation? Or I've never encountered this particular thing in DSM, whatever number we're up to now, 5. Do you have any experience with dealing with this number in the DSM? But attorneys all the time, I've got this case, and there's some stuff about Odinism. Do you know anything about that? You haven't, we have bulletin board rooms, only Texas lawyers, only Central Texas lawyers, every day. And the prosecutors have the same. Every day there's questions. hey, I've never run into this before, but I got a case where they're alleging all of the cops are odious. What do you know about this? There's absolutely nothing improper about that. And I guess the prosecutor YouTube channel was trying to infer that. It's complete and utter bullshit. Doctors, therapists, lawyers collaborate. That's part of what being a professional is, that if you're not up to speed on something, you try and find others who are. You have a duty to do that.
I think
but they abandon it. It's not there anymore.
I think part of this issue was that, and I may be wrong about this, but from what I understood, because of something, maybe there was a protective order or something put on discovery, I forget, but that there was like a certain process you're supposed to go through to be able to have access to discovery. So maybe like each person was supposed to sign something or something like that.
Right. So if you compare the order in Westerman's case with the order that Judge Gold's order is confusing in some parts, but and that may have been that in order to collaborate, again, it's bullshit and it's confusing, the protective order, and because it's understood that you have to send materials out to experts. And that's really what the thing is that you notify the experts, hey, look, I know you'd never divulge this stuff. I know you'd never put it online, but hey, there's an order here and need you to make aware of it. We have a standing order in Texas by our rule that we can't give materials, any discovery materials, to the defendant. We can let them look at them, but we can't give copies to them other than their own statement. Can't disseminate them. And so when we send the materials to the expert to review, there's a cover letter saying, under Rule 3914 of the Texas Code of Criminal Procedure, and I just quote the rule, please acknowledge that you are aware of this rule and understand it. Yeah, so, I mean, that's not unusual at all, especially if the expert, somebody's not normally an expert, that it's an area that, they're not a professional expert like a lot of experts are. That's all they do is provide expert testimony. They're retired and their expertise may be policing and police policies, for example. They're aware that all of these jurisdictions have safeguards about the materials, especially, videotapes of officer-involved shootings. You don't release those to anybody. But, outside of that, that's what they said, going all the way back to Hennessy. If you got a problem on the protective order, you have two choices. Hold a contempt hearing or file a bar complaint. And in the Jones v. Knox case, much to my surprise, wasn't mentioned by anybody. I was absolutely 100% wrong about that. Although I think it may have been inferred in one of the things.
Didn't they mention Knox one time?
Okay, maybe they did.
I thought they mentioned it one time because I think you even said boom in the chat.
Okay, well then maybe I'm 98% wrong. Anyway, so the judge, it's in the opinion, referred that conduct to the bar. Now, interesting is an epilogue. So remember, the attorneys started that motion out. It was, is a serial killer two or more? So we had a serial killer on his case, they start off the motion with this fake letter to their client. Based on what the court's done, your constitutional rights are being trampled upon. Interestingly enough, 2 years ago, that defense attorney became the DA of Knox County. Can't remember his name. There was an allegation of one of his subordinate attorneys doing something improper. The DA reported it to the chief of police with a fake letter, and that was turned over to the bar to investigate. They did a 1-year investigation and at the end concluded nothing improper, but it was interesting. Fake letter in his motion, and then some 20 years later, fake letter to the chief of police. It was an email, but it's that got investigated by the bar. It was determined that he didn't violate any of the ethical principles, but if someone feels really strong about it, they can do a bar complaint and proceed forward. That gets investigated or whatever. It can be handled. The point is that if you violate a protective order and you're grossly negligent in violating the protective order, is that a grounds for removal, or is it limited to ineffective assistance of counsel at the trial? And that's what 95% of the questioning was about today.
Absolutely.
I felt.
I agree. And it's funny because I'm not sure what I expected going into this, as far as where the weight of the questions from the judges would be. But I guess no one should be surprised that that's where the crux of most of the questions came at. Because it's the thing that's probably been the most debated among everyone. I think a lot of people have their personal opinion, or their personal mind made up as far as what they think happened and whether they think it was right or wrong on Gull's part or on Baldwin and Rosie's part. But I think the whole, does this constitute them being removed, and should they be reinstated? It is probably the most argued thing that I've heard people talk about online. So it shouldn't be surprising that that's where the judges were.
And I'm so glad they televised this oral argument, because non-attorneys going in, so they're going to be talking about how, why this was so bad, and then very quickly it went into, they screwed up. They admitted they screwed up. How does that impact whether they're going to be good trial lawyers or not? How does that show they're ineffective? And It went very quickly to what the legal issues were. I think Charmaine and others mentioned several times. It's questions of law. So on this record, if I'm a judge and I get this thing in, I'd be like, well, it can't be the law that the only way you can remove court-appointed counsel, even if the defendant says, I want these court-appointed counsel, I don't want them removed. How can it be the only way you can remove them is if they're not licensed or ineffective? Thus, questions about what if the attorney doesn't show up? What if they miss court? What if these other things? And said, well, in that case, that would be ineffective, and that should raise grave concerns, but that's not the case here. None of the violations that they're complaining about in their brief go to the ineffective or effectiveness of counsel at trial. Said that over and over and over again, and then the other side came up and started talking about buckwheat and buckwheat this, buckwheat that, and saying, well, when he comes back on rebuttal, he better address buckwheat, or he's going to be in big trouble. The Chief Justice actually had a question even before rebuttal about, well, does buckwheat apply here? Isn't that on something else? But they were saying the possibility of ineffectiveness is enough. And
which that's crazy.
Well, and you heard the arguments on both sides, but very quickly the attorney for the court was conceding that this didn't go as smoothly as it should, but he found a case that gave him the room to argue, hey, okay, well, yeah, none of these are ineffective, but we don't need to show ineffective. We can show possibility. And then you heard what the response was of the relator. I'm wondering if anyone had any comments about the arguments of the Attorney General's office. They were referred to in the arguments as the state. What they thought about the arguments of the state. No one's talked about that yet. Obviously, I think because it didn't impact any of you significantly, but does anyone have any thoughts about what the arguments were of the state?
Could you be? I'm trying to differentiate what those were compared.
Well, that answers part of it.
Right.
They didn't line out for you. I mean,
do you mean like just the AG or the entire side?
Well, the attorney from the AG's office got up there and started with her sequela about, I can't even remember, it's like very general and abstract and esoteric. And essentially what she argued is, well, we are concerned about your caseload, and we are concerned about what litigants can bring up as an original action, since we have the right to respond to all original actions.
Right.
We are concerned about that. With all due respect, she's obviously pointed at that judge who said, well, since we're here, which I wrote that down, it was more of the procedural stuff is what she was pounding on.
Right.
And then
technically it should have been her role, right? If she, if she's from the, AG's office, Gull's lawyer himself was the one that would be really arguing for, in Gull's favor, so I'm not surprised that she was, arguing more, for things pertaining to, future cases and, the state's interest in the case. I don't think she presented very well. I think she seemed flustered. I don't think she came off as a very strong speaker. The same as I didn't think Mark Lehman did either, but I didn't think any of the lawyers presented very well. But she definitely she lost me a few times.
I would have been annoyed at her if I would have been a judge, just from her argument of like, the reason we shouldn't do this is because if we look at it on merit, then that will allow, everybody and their mom to come and put all these cases, and you guys will be too busy. Right after they told them, yeah, that's the rule that we have in the past allowed certain ones through. That's like, I would have felt like that was saying, I know you just said that you guys make decisions on that sometimes, but I think that decision is wrong for your own good. I would have been annoyed about that. It's probably petty, but
Yeah. Well, the other thing I jotted down, and I just jotted down a couple of things. So at the end, they're, saying, okay, well, how do you picture this? You keep saying they have all of these remedies and they have all of these options. What are they? Oh, I see my time's up. Chief Justice, you can answer it. Saved by the bell. You can answer it. Well, they can file motions. That was really, really weak. How are they going to file, Baldwin and Rozzi, how are they going to file motions on cases that they've been removed from, where the judge has issued an order that any pleadings they file, they can be received but not filed by the court? Before that, the judge ruled that they be stricken from the record and removed. Her attorney is pretty sharp and probably advised her, don't do that. Like he advised her, issue an order and fix this stuff in the first one and moot it, which was successful. But still, the court took time in the order on the first one. While we're at it, we're going to take the time to explain, the Access to Records Act for everybody so they understand. It's, so she answered that. And then there was one other question the Chief Justice asked her, are there any Indiana cases where the court ruled, and there was a long pause. No, but there's cases from around the country, yada, yada.
Yeah.
And then comes back with, but no, Your Honor, there's no Indiana cases. And basically the Chief Justice was asking for a concession that, well, that makes it worthwhile to decide this on the merits so everybody can know going forward in law schools, like Adam mentioned at the top before the argument, it's going to be a landmark case. Everybody's looking, and not about the case so much, but as guidance to court-appointed counsel and judges going forward.
Right.
And it will be studied if they reach the merits.
They'll be rewriting the law school books.
Yeah, it'll be taught in ethics class. It'll be taught in criminal procedure. I'm sure the law schools there have what we call trial clinics. Third-year attorneys go and work with lawyers on misdemeanor cases. It'll be taught in those clinics. Hey, look, here's what your duties are.
The court's very aware of all that. The court knows the court knows the weight of their decision in this case.
I think they even mentioned it.
Not on the case. I don't think they care about how it's looking here, but they're very much aware. They're very much aware that they need to lay this out clearly for defense attorneys and judges going forward. Absolutely, I agree with you 100%. That's the reason they accepted it in the first place, I think. And Adam, you've talked about that before. They accepted the case. And then number two, granting oral argument, if they do reach the merits, they want it to be clear why in this particular case they did it, so that they don't have a floodgate, Ivy alluded to, of cases where attorneys disagree with the opinion and they're filing a writ. No, it's only if attorneys are removed for something other than ineffectiveness of counsel.
Question, just what is that? Does somebody have their dryer on or something, or?
Does sound like a dryer.
Huh?
I said it does sound like a dryer. That's like a perfect description for that.
It does. There's this background noise. Before
I'm
you guys,
muted.
yeah, maybe it's coming. Travis, maybe it's coming from behind you somewhere, because there's this noise that keeps kind of happening, and I keep thinking it sounds like a dryer. Somebody, Deb in the chat said, "What's that crunching noise?" And I keep hearing it too, but I'm not really sure. Before you guys keep talking there, I just want to say my 2 cents. I thought that Lehman guy started off, kind of stumbling over his words, and he had a, basically grab his feet there, or his tongue. And then I thought he came back really strong. As for Fran Gull's side, absolutely bored the shit out of me, to be honest, listening to them. They sounded so weak, not weak to me. Like the arguments, it's almost like I was almost embarrassed almost listening to them. And then I think it was Rush. She said, "So can you say anything outside of the scope of keep using the wheat?" You know, at one point, and I don't know. I just honestly, it wasn't memorable to me what they were talking about. It just almost seemed like they were putting their foot in their mouth, and it was almost like when the woman was speaking, it was like she was speaking for the attorney general's side. It was almost like, well, you got me there, judges.
That's going to be my argument for everything for the next 6 months. But wheat. But wheat.
What'd you say, Ivy?
I said that's going to be my argument for the next 6 months to everything. Wheat. Can't be right because wheat.
Travis, do you know much about wheat at all yourself?
Yeah, it's grain. Grows in Nebraska.
That one? Meaning, yeah, but because he just kept referring to it
the
so much.
wheat decision, but I know everything about it I need to know.
Yeah.
Because of the questions and the responses of both sides, which shows that, one, Adam's right, the questioning was fair and probing of the attorneys, and number two, that Wheat involved a conflict. Wheat said that the possibility of ineffectiveness is enough. The relators said conflicts don't rise to the level of being ineffective. And the very nature of a conflict makes all conflicts potential for ineffectiveness. And that's one of the things you have to warn the client about if she's sleeping with her lawyer, if he's sleeping with his lawyer. From the get-go, one, that's not what the court found, and number two, it's a whole different animal, and Wheat will be cited. Unlike I predicted, it's up in the air whether they'll even refer to Jones v. Knox Superior Court or not.
I wrote down. Oh, sorry.
Go ahead. No, go ahead.
I wrote something down for I don't know the woman's name, the one who argued for the AG. And I
Lehman?
think, no, the woman.
Garcia or Garza?
Yeah, that sounds right.
Female.
I think Aspen caught a similar thing, but flipped. So if I remember correctly, one of the issues that Gold said that the previous defense wasn't honest about was their motion to move him and for their reasons, and one of those was his mental health. I think she basically was saying that the mental health issues they were claiming wasn't true. But then when Garcia was arguing, she said, well, we don't really know what Richard Allen wants, what his opinion is, what his wants are for who his attorney is, and his mental health has been brought up, so we don't even know if he can make that judgment soundly. So right there, there's like a conflict between whether they were accurately describing like his mental status between that woman and Gull's opinion.
Ivy, what do you mean between that woman's opinion and Gull's? Because Gull's never issued an opinion on Richard Allen's mental state.
I thought part of her saying that they were being dishonest in the moving, that part of that was because of she thought that they were misstating his mental status.
Are you talking about the lawyer that was? Are you talking about the lawyer for Gull that was arguing that said that that we don't know, we can't trust what that Richard Allen, that we know what he really wants? Yes, are you actually talking about Gull herself?
Both.
In Gull's
and that's where Adam said, well, how can he be competent to know whether he wants these attorneys or not, but not competent to confess?
Right, and I understand like the argument that that's something that'll be argued at trial, but my point was that any question about Richard Allen's competency, which none of us can answer because we're not licensed, and he has been evaluated from mental health professionals, and as of now he's been deemed competent to face the charges that he's up against.
I don't think they've had just a nitpick, I don't think they've had a competency exam. If I remember correctly, the assessment they did was to decide whether or not he needed to involuntarily take medication. If I remember correctly.
I'm only stating that he has been, that we know that he's been evaluated by mental health professionals, and as of now, there's not been a question of him being competent or not competent in the case. There's never been.
He said that he was mentally fine.
Yeah,
I thought they said that he didn't need to involuntarily take medication because those are two different things. I'll have to go back and look.
I don't know. I haven't followed it closely. I've heard other people say he's been deemed competent to stand trial. And then depending on who's doing the presentation, they'll say, yeah, he's competent to stand trial, meaning.
Yeah.
Right.
And then the defense perspective that they're talking about, to be deemed competent to stand trial, you basically need to know where you are.
Right.
What a judge is, what a courtroom is. And that you can't take too much from being competent to stand trial as to being, fully aware, like
Correct.
all of us, what's going on. But
I'm basing my opinion. Sorry.
Go ahead.
I'm basing my opinion only on what I've read in the motions that have been filed throughout court. There have been defense motions where they've talked about Richard Allen's mental state, but no one has actually requested a competency hearing in this case. That was my only point. So, if we look at the merits of them saying, can we really trust that Richard Allen is competent to know what he wants, or has he been given the information other than just secondhand of how to make the decision? I don't think you can then separate his ability to write a letter saying he wants them to remain his counsel and then say, but you can't listen to anything else regarding his competency. Because it has to be considered that if he is mentally able to decide he wants these two attorneys to represent him, it should also be acknowledged that he apparently was mentally competent to confess to his mother and wife 5 times.
I don't want to.
And I know that should be argued at court. I'm just saying you can't cherry pick the two. And I think both sides in this case have done that. And I just don't think it's appropriate to separate them.
Well, my deal on that is it was a blunder for the court's attorney to try and argue, we don't know.
That's what I
It's
was saying.
unclear.
Right.
I think they got their ass handed to him in rebuttal when he read the entire letter.
No, I think I agree with you. I think that was a strong. I think that was definitely a strong part for Lehman.
And then I think the chief judge said, "We get your point. We have the letter." Okay, we get your point. Part of that I think was for show, and I think the chief justice saw it as part for show rather than just saying, you have the whatever the date of the letter is, October 12th letter. He's abundantly clear. He also referred but didn't quote the hearing where they went out, spoke to Alan. Rozzi came back in and said, well, if you want to hear him say he wants us, he's willing to do that. Don't know how that's going to work. Well, I don't want him in my chambers, which I didn't take as good, bad, or anything. Just don't want a prisoner in court chambers, which usually aren't big. But he referred to that where he was also clear, and everybody remembers the exchange. Well, assuming you'll take my representation, Judge, well, you wouldn't lie to me about that. Rosie, well, I wouldn't lie to you about anything, Judge. There's no issue on the record that he didn't understand. And really, the most important point is the court wasn't challenging his competency on the issue of which counsel he wanted. It was accepted and assumed, and they went forward.
We lose him.
Whoops, Travis, we lost you again.
Can you hear me?
Now we can.
Okay, yeah, I just was done that there was no issue. The court accepted as true that he was competent enough to indicate to the court that he wanted Rozzi and Baldwin. And that even came up in the October 31st hearing, where I think she addressed Richard Allen and said, I'm sorry, I just cannot keep these attorneys on. Just that wasn't an issue down below, we called it. That's all I had to say.
What were you going to say? There was something you were going to say, and then
Me?
Well, Travis was talking, and you were talking at the same time originally.
I was going to say, I don't want to get into the weeds of this, and it's probably just me nitpicking, and it doesn't even apply. I'm not saying this specifically about Richard Allen, just in general, but for one, there's a difference between legal competency, like Aspa was talking about. There's, if you have the hearing and whatnot, versus their mental status, while in prison, and mental status can change day to day, hour to hour. So just because somebody is mentally stable at one point doesn't mean that they are always going to be mentally stable or have always been mentally stable or competent enough to make decisions and understand things. And again, I'll have to go back and check. I'll get back with you. I want to say that what they assessed him for was just if whether or not he required involuntary medication, which is a pretty high bar. You can be, I don't know what the rules are if you're in prison, because then you're kind of under they're your custodian in a way, versus as a free member of the public. But it is extremely hard to involuntarily medicate people on the outside, at least. I'll have to check on the rules on the inside.
Yeah, so where mental competency comes up the most is when a client gives a statement, confession, whatever you want to call it, and they're, obviously completely intoxicated on alcohol or something else. In order for Miranda to be effective, you have to knowingly and voluntarily waive your rights. So it comes up a lot in that context. Is he mentally competent, either because he has a 70 IQ or he's intoxicated, to waive Miranda? And then the other context is so knowing and voluntary at the time, see that a lot. And the other where it comes up is competent to stand trial, and they're evaluated briefly. And the folks who are determined to not be competent to stand trial, it's very, very clear that they're not. They're talking to themselves. They're in total disarray. It's people have encountered folks like this maybe on the street, and it's just obvious to anybody that they're just not all there. And what they do is they send them to a state mental hospital that's a secure lockdown facility. They put them on medication and get them competent, 3 to 6 months, and then they're sent back and they stand trial.
Yeah,
Happens.
It's not
Yeah.
like you just get released. I think people have kind of like a misconception about that, or they haven't thought about it all the way. And I'm not talking about our conversation here, but like other places about competency and whatnot. Once you're deemed not competent, they don't just let you out. It's not a way to get off.
No, in Texas, they get you competent so they can try you and execute you. I mean,
Yeah.
It's
if you're lucky in Oklahoma, you don't even have to be competent to get executed.
Yeah. So no, it's not an insanity defense. It's not whether you had the mental capacity to form intent at the time of a murder. And I thought they were absolutely clear about that in the motion to transfer, that they said the conditions, he's losing weight, he's, not his normal cheerful self, or he's not as responsive, or, something to that effect. He's not the normal, he's not the regular person I first met.
He's in prison.
Yeah. So, but it has nothing to do with legal defenses in the case. My take on it, the long and the short of it, is that issue of whether he knowingly and voluntarily is knowingly and competent to indicate to the court his desire for counsel, it isn't going to be questioned.
So Travis, how long do you think, just your own guess, how long do you think we hear back? Do you think it will be it seemed pretty clear. I think it did seem pretty clear. Like they want to get this case moving forward. And it did seem pretty clear for the most part.
Yeah, so I've researched all of the cases and the time frames.
Yeah.
So I think I have a pretty good idea on this, and so I'll lay this out, give you my best guess, which that's all it is a guess, and then
exactly.
I've got to run, but I'll be listening in. So they meet for conference, the 5 judges, every week. I don't know what day of the week it is. Maybe Thursdays. And so they could meet this afternoon and say, what's everybody think? So let's say it's not until next Wednesday. So it'll be a week, they'll get together. If they're going to grant it in part, I believe what they'll do is put together a 1-page opinion saying we're going to grant this, deny that, And I believe that'll come out within 2 weeks. And that they'll indicate that they're going to provide a more detailed opinion, and that'll come out in 60 to 90 days. But if they're going to grant part of it, I believe in within a couple of 3 weeks, we'll know that. If they're going to deny everything,
Yeah.
I think it'll be like with the first petition. Even though it was a denial, they explained later on in the opinion what Gold did was improper, but was now moot, that this is what you need to do, what they expect going forward. If records, documents are sealed, that the proper forms be filed. They issued that in 20-something days after the case was finally submitted. So I think if they're going to deny everything, we'll see an opinion in about 3 weeks. That's my best guess.
Can I interrupt? Sorry, I have no patience, and I'm very impulsive, so my bad. But they just put out, there's a new filing, and it looks like
Ivy, are you still there? She's leaving us with a tease. Ivy.
Man, I got on a different page to read it. It's in our chat. It's a,
okay, hold on.
They changed the charging, but apparently I can't read if I'm on a different page and you guys hear me.
Okay. They just put this out on the 18th. Okay.
Yeah.
1 second. Just the 2 pages there, Ivy?
Yes, from what I've seen.
Okay, hold on. Let's see. Let me grab it. Okay. Stop screen. Present. Share screen. Okay. So go ahead, Ivy. If you want to read it, go ahead.
I don't have time to read it. Let me blow that thing up and let me see. Motion for leave to amend charging information. Interesting. Okay, well, that goes into the case, and you all certainly can
Scroll down.
dig into that.
Yeah, you said you had to go in, didn't you?
Yeah.
Okay, do you have to get going right now?
Yep.
Okay.
But
well,
this doesn't have anything to do with today. It won't have any impact whatsoever on what's happening today.
I'll make that bigger. Okay.
Go to the end, the conclusion. What are they asking it to amend to? You're seeking the death penalty now?
Are you talking about the second page?
Yep.
Okay. Let me bring that one up. Hold on.
I think they're adding kidnapping, I think is what it is.
You think it's what?
I think they're adding kidnapping.
Yeah, and if it is, we've kind of talked about this in prior presentations under felony murder, which people get confused all the time. Kidnapping, you have to have an allegation of kidnapping for felony murder. If you want to enhance the penalty in sentencing to life without parole, or
Oh wait, I'm wrong.
but okay.
It looks like they're changing it to regular murder plus kidnapping.
Okay. Well, there's a lot of legal reasons. It's going to require its own show on that to try and take little pencil stabs at it. not going to do it justice. We want to do that tonight. We can, I have time, but there's very complex reasons for doing what they're doing here with regard to what they have to prove at trial for murder, number one. And number two, what the potential ultimate punishment could be. 60 years max versus life without parole, or this could be a pathway to seek the death penalty.
Okay.
So
Well, go ahead,
I was
Ivy.
just going to say, so you think, just before you leave, so you think that this would point to something good for the prosecution, that it makes the prosecution's case look better than maybe a felony murder, just from us guessing of what they have?
Not so much that they have something better. I think it's that they're cleaning up their pleadings.
Okay.
And now's the perfect time to do it. I mean, we really do need to dig into this because
Yes, Skittle.
if this is a pathway to the death penalty, the timing of this is certainly in question, because you have to be death penalty qualified, which Baldwin is. Rozzi, maybe no, I can't remember. Anyone see a possibility of reinstatement of Rosie but not Baldwin? Anyone think that's on the table?
Oh, which reminds me is if somebody answers that, but I had a poll saying, will Rozzi and Baldwin be reinstated? 52% said yes, 24 no, 24 unsure. So I mean, I'm not really getting that vibe myself about picking one over the other. I think it's both or none type of thing. I
felt the judges would have brought it up like they did the pro bono thing, wouldn't they?
Yeah, I would think so, which that to me was a tip of the hand where that justice was going. And then, but not always, you know, if they ask a question about, okay, well, should it be $1 million in damages or $2 million? Doesn't necessarily, that kind of tips the hand that they're going to find liability against the other party. And it's a question of how much, but not always. But I took that where he was going, but you know, they did not ask any questions like that whatsoever. It's like, okay, well, that's Baldwin, but what about Rosie, which Adam and I have debated or discussed, whatever you want to call it, in the past, and you know, I agree that it's going to be both or none, but that, just so everybody understands, that's an option they have, that the record's absolutely clear that Rosie wasn't incompetent, didn't have a conflict, wasn't ineffective. It's more of a question on Baldwin. We're going to reinstate Rosie and move forward. Could be, but I agree. Some wasn't addressed, so. And I wouldn't have gone into it if I was attorney for the relator.
Right.
Makes a conflict for the attorney to be saying, well, yeah, Baldwin, we don't care what you do with him, but Rosie's squeaky clean. You all take care. Thank you so much for having me. I hope
Thank you, Travis.
what I had to say was helpful to somebody. And if you want to talk about this pleading tonight and get into the specifics of the technical issues on charging instruments, we can do that. You just send me a text or email.
Sure. Thanks, Travis.
Thanks,
So,
y'all. Be
and
safe.
you too.
Thank
So,
you.
if they keep their database or list or whatever you want to call it up to date, I don't see Baldwin or Rosie on the death penalty, if I'm looking at the right thing, or Scrimmin or Librato. So that would make it kind of crazy if they did the death penalty. I don't know. Maybe I'm looking at the wrong thing, or maybe they don't keep it updated.
I honestly don't know. It's I'm sorry. I was half-heartedly listening because I was trying to talk to Frank, and he was kind of in the light.
Oh, sorry.
No.
You're fine. I'm just sitting there reading this document. That's all I'm doing, guys.
Okay. Yeah. So let's go back. Okay. So let's go back to this document and put up here. Let's see here.
Who do we got? Who do we got on panel here? I know we got Aspen. You. Who's the young lady?
Ivy. So Ivy Rose. You probably seen her.
Yeah, I know. I know, Ivy. Yeah.
Yes.
What's going on, girl?
Good. Nothing. How are you? How was your day so
Well,
far?
I mean, we got there at like 5:15, and the quorum told us we all had to meet up at the north end of the Capitol building, and that was incorrect. We had to meet at the east side.
That sucks.
One second.
And
I'm still here.
there was Mama Lieber Scales was there, Murder Sheet was there. There wasn't but me, Mama Libra, Murder Sheet, and maybe one or two other YouTubers, but I didn't see anybody I recognized at all.
So did you not make it in?
Yeah, me and Rescue were the first two in because we were the first two in line.
So did you say Murder Sheets was there or wasn't there?
Yes, and they got a press pass, a media pass.
Oh, okay.
So, yeah, they sat with the media. We sat directly behind Tara, and Becky and Mike sat in the front row. Tara sat right behind them. We sat right behind her. Dave Vito sat right next to me. Holman sat right next to Nick McClelland in the front row.
Everybody was there.
Yeah.
Yeah, sounds like it.
All of ISP was there. Rosie had this shit-eating grin on his face through the whole hearing. Smiling and shit.
I probably would have too if I was him, to be honest.
I mean, not to damper the prosecutor, but I'm telling you that people that represented RA, they put on a hell of a fucking argument. I'm telling you.
Yeah.
They put on one hell of an argument. So, I mean, to me, the way the Chief Justice was acting, they're leaning toward the defense.
Mm-hmm.
That's just the way I've seen it.
That's the way we saw it, I think, too.
You know.
I wonder if it's normal for all those people to be there, or if this is a unique case.
You talking about all ISP and all of them?
Yeah.
I would imagine so, because it was their investigation that led into the leak. So that's why they were all there.
Did you go ahead, Frank?
It was almost like a waste of time to me. I mean, it was nothing but basically going over the motions that were filed with the Supreme Court. That's all it was. Repeating over the same shit that we've been talking about for the last, month? And that's all they did.
Okay. Because, I mean, it was one of those things that I think, I found this very interesting to be able to watch Supreme Court live and then sit there and we knew that what they were going to be talking about. And it's just a matter of basically them representing their arguments. And then, of course, a decision coming down with obviously who's going to get, are they going to be allowed back on, reinstated, Jan Gull being removed?
I could see Rosie possibly being put back on. Honestly, I can. But as far as Baldwin's concerned, I mean, if I was the justices, it'd be instantly in my head thinking, well, it was neglect on his part in the first place. It don't matter whose conference room it was the pictures were laid out on. Anybody in that office that works there has access to that conference room. Anybody could have gone in there and seen those photos. You
The
know, so
question
that's,
is neglect enough to remove him?
I think it is. That's just my opinion, because they violated the gag order twice. I mean, what else do they need to do to get kicked off the case? You know
What
what I
were
mean?
the two? What do you think the two violations for the gag order were?
The memorandum and the pictures getting out.
Well, I don't think the memorandum is violation of the gag order because it's in a court filing, and that's not included in the gag order. I forget if it's the gag order or the protection order that does that, but court filings are kind of protected from that. And then
Well,
the picture.
Rush said though that they didn't violate the gag order because the gag order came after the press conference.
the gag order was put in place in February of 2023. Then you got to remember that they dropped that 136-page memorandum, which they were describing the crime scene, and they were not supposed to do that. That's a violation right there. Then
I disagree.
And then the pictures being leaked out, that's another violation.
See, I took it as that they didn't seem like, meaning when Judge Rush was talking, it came across like, so you're trying to say that these are big violations which caused the judge to remove the counsel. Like, that's how it came across. Like,
yeah, that's the way it came across to me also.
Yeah,
because a court filing can't. A court filing can't violate a gag order.
If they put information that's under the gag order in that document to be filed and it's released to the public, that is a violation of the gag order.
The gag order didn't include, I'll have to find it, but the gag order doesn't include filings. And I think even Judge Gold said that the things that should have been made, what is that word where they black stuff out?
Oh, redact.
Yeah, it should have been redacted was, of all things, Libby and Abby's names, not even like the names of people accused, but just Libby and Abby's names, was what she said should have been redacted out of the entire thing.
I mean, that's just the way I feel about it. I mean, if you're giving the public information about the crime scene and everything, to me, that's a violation of a gag order.
see, now Travis had said that wasn't a violation. Whoops. Hi.
Thank God I'm not a lawyer.
Was it February 2023?
It was, yeah, 2023 February. Yeah.
Can you guys hear me now?
Yeah.
Yeah.
So, for the last 25 minutes, I didn't realize that I had no audio because I wasn't muted. Like my thing had cut out. And I was like, why is no one listening to me?
I mean, then you got the state did make a good argument, though, saying, look, they intentionally put this stuff out there to tamper with any type of jury pool. And that's honestly how I feel about it. They intentionally did this to affect any type of jury pool. That's just how I feel about it.
Sorry, Frank. What did you just say there?
I said that I feel like, I done placed a brain fart.
Oh, yay. Ivy, what did Frank just say?
You said that you thought they put it out there to tamper with the jury pool.
Yeah, I thought they intentionally did that to tamper with any type of jury pool.
I agree that they put it out there, and kind of like what the prosecutor's podcast said, like, meaning they have the option to click, public or private or whatever it was. I believe that the intent, like, to me, I'm sorry. So, I mean, if I was basing it on my personal opinion, I feel like that Baldwin is a slime ball. That's how he comes across to me. He comes off like, like Rosie comes off a lot more cleaner looking to me than Baldwin. Baldwin just reeks to me of antics, tricks, manipulation, that type of thing. That's just my own personal opinion. Now, whatever happens with regards to today and what the Supreme Court decides, I'll be fine with, because, like, whatever is decided, to me, I'm just going to take what exactly happens, whether it's the reinstated or not. I'm not a Supreme Court judge. There's 5 of them up there. I'm sure they'll come to the best decisions for the case. I would like to think, but doesn't mean I'll agree with it. But yeah,
I
anyway.
think the main concern that the Chief Justice was talking about was getting this case moved forward.
Yes,
That's her main concern. From what I could understand what she was saying up there, she's more concerned about getting this case moved forward, and with all these stall tactics and everything that's going on, it just needs to move forward.
Right. And I think we could do a whole stream on this new filing, but to me, I think that this could easily be also looked at as, I feel like the burden of proof on the state was less with felony murder, and there was no one making the state change the charges, and to me it shows that I feel like the state is exceptionally confident in the case they have against Richard Allen, that they're willing to go with these new charges that are harder for them to prove.
And I heard a little bit of what you guys were talking about while I was sitting in the background. They might have done this to open up the possibility of the death penalty.
Again, a harder burden to reach.
Exactly.
So to me, it shows confidence in the case they have. I'm not saying that they should. I'm just saying, to me, it shows confidence in the case that they have.
Well, the way I look at it is the original charges I thought was the right idea, due to the fact that even though Richard Allen is allegedly admitted to his wife and his mom that he is the one who ordered the girls down the hill, I think that would have been a lot easier to prove than try to actually prove that he actually committed this heinous crime.
And they're going a step further and now going to have to reach the burden of proving that he committed the crime of murder and kidnapping.
Exactly.
I'm not saying that I believe this. I'm just being a devil's advocate here. You could also look at it as in felony murder that you have to prove that he kidnapped the girls, and then that led to murder, which, sidebar, you would imagine that's fairly easy if you can prove the kidnapping. But then you could also argue that if you split it up, if you can't prove the murder, then you can at least prove the kidnapping. So even if he got off on the murder, you could convict him, pretty sure, on kidnapping based on those admissions. Again, not necessarily my opinion, just devil's advocate.
I just saw Brown School talk about Baldwin slimy and Rosie's arrogant. 100% correct on Rosie. That some bitch is arrogant. He thinks his shit don't stink. He thinks he's Italian, walking around with his greased, slimy, bald hair.
Tell us how you
You ought to see this guy, man. I mean,
I still like his dance, though, Frank, that he did when he did that.
I'm just like, who is this guy think he is?
But man, I'd hire him though if I was.
Well, I mean, true.
I'd marry him if I wasn't already married, to be honest, by looks alone.
Well, but like I
No,
said,
go ahead.
he was sitting up there in the front row, and I just seen that smile on his face. I was like, oh, Lord.
Yeah.
You could see a portion of him in the camera, but because he was on the aisle seat.
Yep.
Tell us how you really feel.
Yeah, tell us how you really feel. Did you answer this? Was Doug Carter there?
No.
Yeah.
Yes, he was.
He was. Okay.
Yes.
And I wanted to ask you, did you end up talking to Becky and ask her anything? No? Okay.
No, they took the family straight out of there into another conference room.
Right.
Okay.
And then you said Baldwin and Rosie left right away. Like they
right
didn't.
away.
Because I was wondering if they would talk, to reporters or anything like that. Or I'm surprised even that the lawyers didn't, but I've seen nothing.
Did Rosie
Labrada was there.
Yeah.
Labrada was there.
Okay.
Yep.
He was probably going, well, it looks like we're handing this case back over.
Yep.
We won't have to make that 10-hour drive. No.
Yeah. I can see.
What if they make all of them do it? All 4 of them.
All right. There's another option.
I mean, and I go back to where these new attorneys filed that motion to transfer him, right?
Yeah.
If you go back to the affidavit that Richard Allen had written, they basically, all they did was just transcribe that affidavit right onto that motion, is all they did. It's nothing new that they discovered. It was just something that was brought back up by Richard Allen, and he wanted them to push that narrative.
I disagree about that one too, because yes, a lot of it was there, but then you have the addition that now, and he was like the conditions they described for meeting with him as an attorney was worse at the new prison than the old attorneys described at was it Westville? I always get Wabash.
Yeah. Well, I would, in a certain situation, I would have to agree, especially when they were talking about when they had their meeting with him down at Wabash, talking about a table
away?
was 6 feet away, and he's talking through a tray slide.
That's ridiculous.
But the Hannibal Lecter was a little over the edge.
Yeah.
That was a little over the edge.
Yeah.
And they spelled that wrong too.
Exactly.
I have a question for everybody. Maybe I am like looking at people giving what am I trying to say? My standards too high. But I thought after all those years of education, people could use a grammar and spell check.
Thank you.
It automatically does it for you on the computers and a phone.
Well, I mean, I'm not a lawyer, but you think a lawyer could spell affidavit correctly?
Yes.
Right.
My text messages are more proper than these like court filings. It's ridiculous.
Right.
Honestly, I'm always amazed at just how much we see now in misspellings and everywhere.
On both sides.
Frank's hearing with the apostrophe, not necessary.
Who's Frank?
I don't know that it underlines red to tell you it's something to look at. It's spelled wrong. You hit right click and then you spell it the right way. It happens to me all the time. But yeah.
So, Frank, do you have any other takeaways from being in there today? You know, like that we wouldn't have gotten them from watching it on the live stream.
Not really. I mean, once it got started and I started listening to both sides, I'm like, man, this is basically a waste of time. I said, this is the same shit they filed. They're just going back over the same stuff over again. And I'm just like, what's the purpose of this?
Did you feel like there was any reaction like from like say the families or anything while they were listening to what was being said?
I saw the look on Tara's face because she sat to the left of me in front, a couple seats down from me to the left in front of me. And there was one, I can't remember what part it was, but something was brought up and her eyes just opened up real big, like, what the fuck?
Do you know, Frank, because I've never asked this, but maybe you have asked Becky or Tara, whoever. Have you asked them if they prefer that Rosie and Baldwin be brought back to the case, or would they prefer to have the new?
I haven't discussed it with them yet.
Okay.
But like I have had a discussion with Becky about screaming. I said, now how in the hell is if they keep him on the case, how's he going to get around to admitting that the bullet evidence was good evidence in his eyes? How's he going to get around that? It's like my last live, I explained, I said, look, Allen County, probably 20, 30,000 or Wabash or Fort Wayne, whatever their amount of people that live there, I can guarantee at least 60 to 70% of people have seen that interview. Mm-hmm. And if you're pulling a jury from the same county as the public defender who did this interview, people have had to have seen it like, really? How are you going to defend him? How are you going to tell Richard Allen that bullet is good evidence? I guarantee Kathy Allen's already saw the video and she's like, Richard, we got to get rid of him because he's going to get you convicted over the bullet. I could just see it. I could just see it already. So
if you had your way, which way would you like this to go?
From what I heard today, Judge Gould should stay and probably just give her some type of reprimand or something like that. And I do see Rosie possibly staying on, but Baldwin, I don't. No.
Ivy, what about you?
I don't know. I think that the relator side will win. What that means, I am not sure. I don't think that only one will come back because I feel like if that was an option, they would have asked about it like they did the pro bono option. So I think the attorneys will come back and then probably Goal will remain because they didn't really ask them any questions about her.
Right.
But I that's a toss up though. I wouldn't like bet money on any of that.
Yeah. Adam?
I agree with you as far as like I don't see them separating Baldwin and Rosie. I think they're gonna rule on them as a package. And you know, going into this, I didn't feel like the case for Rosie and Baldwin to stay was as strong as I do now. Which, you know, I think it's important to be able to change, you know, when you're given new information or new evidence. I felt like, you know, judging by the questions the judges were asking, I would be surprised if they didn't get reinstated. But I also don't have any inclination that Gold's going to be removed, which in itself is going to be interesting.
Yeah, I don't think she'll be removed either. I mean, I'm just saying that just from her credibility and her co-workers and everything, all different judges, attorneys, even the governor sided with her to get promoted. And I'm thinking to myself, well, if any of those justices up on that bench had a problem with her getting promoted because the situation was going on, I'm sure they would have stepped up and said something. That's just how I feel about it, because they're the high court, so they have the decision over all judges.
I don't really know how that process works, to be honest. I didn't pay much attention to her new position. I can't even think of what it's called.
Well, that new position it's really specific to just Allen County. So the people that appointed her to that position, those were Allen County judges. I don't think there was state input outside of Allen County to that new role. I kind of equated it to being elected president of your HOA. I mean,
Right. Yeah.
it really, it's nothing that would be full time at all. I mean, it's not something that's supposed to even distract from her day-to-day responsibilities.
I would like to know what Governor Holcomb's take is on this whole thing, because he's the one that signs off on the promotions for any judge. It doesn't matter if it's Supreme Court or if it's a county judge or where it is.
So he can veto things if he wants to?
Yes. He's basically the president of this state, is what it is.
For now.
For now, yeah.
I'm guessing that her illness is a factor anymore, because I totally agree with what Aspen said about this position is going to take a very small amount of time. But if you were having health problems that was keeping you from like doing your job already, even if it was a small amount, you wouldn't want to add it.
Right.
So I'm assuming that her health issues aren't a factor this time.
Yeah.
Right. Unless, is she doing it from home though?
I heard she was
she's back
working home.
No, she's back. She's on the bench today. Actually, she's on the bench in Fort Wayne today.
Okay.
That's why she wasn't in court.
Well, I mean, doesn't mean she's on the bench though, Adam. I mean,
No, she's presiding from the bench in a case today in Fort Wayne.
For sure.
Mm-hmm.
And I
Even if
guess
she
so.
You can't preside over an ongoing trial from home. Like, there's a trial happening at the, like today that she's presiding over. She's not doing that from home.
Saw a judge do that the other day. Because it was snowing. But yeah, so.
Well, Frank, get a ride to Fort Wayne and just let us know if she's at the courthouse.
Yeah. All right, you trying to implicate something here, Adam? Yeah, you know too, don't you?
Yeah.
Everybody knows.
What are we knowing? I don't think I know.
Adam knows what's going on. So does Sonny.
Oh, I'm out of the loop.
Yes, you are.
Wait, Frank, what do we know? I think I'm confused now. What do we know?
Hold on, let me text you real quick.
And that's 1 second. And QWERTY, that was funny. The gull over here.
You know what's funny? Sometimes when I type in Gull's name on my text, it autocorrects to gullibility.
Hey, Aspen, don't mention that name, but that's what.
Okay, yeah.
You heard about it?
No.
Okay, we'll talk later.
Okay. Yeah, I was out of the loop on that too. But no, I mean, I do, you know, like if someone, I do think that Judge Gull is actually in court.
I think, you know what, I took it that way.
It was also 3 months ago that she had the health thing.
I heard she ended up going back to the hospital again here recently.
I didn't realize how long ago it was, time-wise.
Well, maybe she will again, knowing that the people that were for the state and that female seemed like they were on the defense side when they were answering the questions. Well, you got us there, judges.
You talking about saying whatever that little short black-haired girl?
Yeah.
She was stumbling her words big time when she was up there talking to the justices. Like, man, is she even an attorney?
She was from the Attorney General's office.
I'm like, where's her vocab and all that stuff coming from?
It just seemed like they were so weak. Like
Yeah.
they stood there like deer in headlights when it's like, oh shit. And then you could see at the very end with that female chick, whatever her name was.
Yeah.
That she was sitting there and she stumbled. She totally was looking for the words to say, and then she ended up kind of mumbling and going, well, you know, I mean, there's emotions to that they could do, and I'm just like, you literally, oh yeah, red light, is there a red light there? And then she thought she was saved, I think, for a second, but it was almost like
she was scatterbrained.
Yeah, she had scatterbrained, and it was just like throwing bullshit to the wind all of a sudden.
Yep.
And I just felt like that happened quite often, even with that guy, that Goshwin, whatever.
And he's supposed to be the expert in front of the Supreme Court because he's argued of many cases in front of them.
And even he came off like, it's kind of like he kept going to wheat,
yeah,
wheat that, wheat that.
Like I said earlier, I didn't think Lehman did a great job. He got better. Lehman got better as he went on. He started out real shaky, in my opinion.
Yeah.
But I wasn't impressed with actually any of the attorneys.
Well, it's awful funny that Winnicky didn't even go up there to speak, and she did a lot of the filing.
Well, she said prior to court that Lehman was going to be doing the actual oral arguments, and that she would be helping to prepare what they were going to be doing. So I think she all along said she wasn't going to be speaking.
I think she would have done the best job. To be
I do
honest.
too.
I agree.
And having an oral argument is like, I mean, it's not completely rare, but it's not common either. So
No.
you don't get experience doing it really, unless, that would be very out of the ordinary for somebody to argue a bunch of times to get experience. And it has to be so daunting it's like a dissertation, which is one of the things that's kept me from getting my PhD. And just the thought of having somebody, like a panel of people asking you questions, trying to trip you up, and you have to remember everything. Oh, it would be
I
terrible.
noticed that with the justices today. They were trying to trip up Lehman.
I think they were both sides. And I guess trip up, it's kind of negative. I think they were sussing out, I don't know if that's fleshing out the argument of like, yes, these are your arguments, but why? Why are they right?
It almost seemed like they were trying to test each side what they knew about the law. To me,
yeah,
I was just like, damn.
Daisy, you're not the first one to say that. I got a couple of messages of people thinking that he sounded really confident, and that's why he came across boring, is that he was smooth. I felt like I felt like some of his arguments were a little shaky. But it's funny that you said that because you're not the first person that has said that.
Well, the judge said, basically, can you stop saying wheat?
Yes.
Give me another example.
She was tired of hearing about wheat.
Because she was putting wheat up against the Sixth Amendment, like kind of like, so you're going to say that this overrules his Sixth Amendment rights and blah, blah, blah.
And not even the same situation. I think he was a good speaker. Like, he did his lawyer arguing well, but the arguments he had weren't great ones. He didn't trip over his words and get all flustered as much.
No.
I would have liked him, honestly, to quote some other presidents instead of that wheat, man. I was just like, man, there's got to be other presidents here that you can go off of instead of
apparently there aren't.
I think that's the problem.
It's kind of like, to me, he kept saying this wheat, talking about wheat. And then when the kind of like the judges came back at him, and then they would, like pose a question to him about if it was ineffective or whatever.
Right.
And it's like they couldn't really go. I don't know. It was almost like he just kept going.
Well, I think that's one of the reasons that this whole argument is so interesting, is because there's not a ton of precedent for it, not only in Indiana but across the U.S. There was a mention of a U.S. Supreme Court case early in
Yes.
when they were talking to
Rikita. Well, Rikita even said something about it in his brief.
But then it really just kept going back to the wheat thing, and I think that it's because there really isn't any other precedent in it, which is part of why it's so complex.
Sonny, you don't even smoke, so why are you even putting 1111 up here?
She wants to make a wish.
That's a vape cigarette. That's not what I do.
You know what was funny?
Oh, sorry.
No, just one second. What was funny is that my husband, so I was cleaning up the kitchen, like going through it. My husband was doing the living room, and he was cleaning out our fireplace thing that we have, mantle thing. And all of a sudden he goes, because I haven't smoked now since September, so like 2.5 years. Mm-hmm. And then from when I was in the hospital, and then I quit. Anyways, husband all of a sudden pulls out these 2 packs of smokes from back behind where he hid them. I never knew where he hid them. I never asked where he hid them. And all of a sudden he's like, pulls out these 2 packs of smokes and goes, remember these? Remember I hid these? And I was like, and then he goes to go throw them in the garbage. I'm like, no, wait. You probably sell those because they're like 20 packs or $20 every year a pack, right? And he just threw them away. And I was like, okay.
Oh, before the hearing started, I saw a picture on, I think it was Barbara McDonald's Twitter that was showed a canine dog walking through the queue. And I literally sent Deb a message and I said, well, there goes Frank's chances of getting in.
Well, that little bastard came up and started sniffing my hand. I looked at that cop. I said, you need to get him away from me. Get that dog away from me. He walked right up to me and started sniffing my hand. I was like, oh, God. Is he going to smell the weed that I smoked last night?
Freaking canine.
I had to, when I saw it, I was like, well, I got to send Deb a message. She'll think it's funny.
I even told Rescue, I said, man, I wonder if that dog smelled the weed I smoked last night. But he just sniffed a couple times and walked away. I was like, shoo-wee.
Smoking it last night isn't illegal. Just having it today is illegal.
Yeah.
But having that smell would have got me searched.
Yeah, true.
Oh, sorry. Husband didn't message back till 11:12, just so you know. Because me and him, sometimes if we sit, we have a little competition, and I'll be like, I win 11:11. So I beat him. He didn't get back till 11:12. Oh, anyways, Little Gambler says, what do you guys all think of Nick's new filing this morning? We're talking about this one right here, right?
Mm-hmm.
Yeah. I actually haven't read it yet.
I didn't even know about it until Aspen contacted me and said, man, have you seen this yet? And I'm like, no.
Yeah, it came out. We got Ivy. You talking about this one here, right? Because Ivy got it.
Myself.
It hit Doc's pop after, because my email going, you have a new thing.
My Doc's pop.
Right. When I've already spoken to Carroll County, and like that's the only thing, because there's a couple things. If you look at Doc's pop, there's I think 1 or 2 other things that popped up on there today. They've gotten nothing else so far.
Yeah.
What were the other things? Do you remember?
One of them was like, I have to. Where was it? Sorry.
I wonder why I didn't get my doc spot. Oh, there it is. Okay.
Literally, one of them was just like, it says.
Of course he is, Courtney.
Like one of them just says new information, new. Filed by the state of Indiana. And then the other one is the file to amend charges, which is what we have.
No, I'm not quirky. Well, what the hell you came up with that shit?
I thought it was Adam that went BRB because he was having a phone call with Gull.
You mean Fig Solves Ant?
Yeah, Fig Solves Ant. Yeah.
Keeps going on about Frank's, Ben. I got you.
Yeah. Courtney,
What
she's gonna-
about Sue's son? Everybody,
Yeah.
how's everybody relate?
We have Sue's son, and then we have Gull's nephew, Fig. I don't even know how that rumor got started. It's just the silliest thing I've ever heard.
And probably like a second cousin twice removed that lives in Canada.
Oh,
then.
absolutely.
Absolutely.
Did y'all see the conversation with Fig and Kay Weber?
No.
Yeah, I did.
Yeah. Okay.
Is it on a video?
No, it's screenshots from Messenger between Fig and Kay.
Oh, Sonny.
Yeah. No, Adam would have to share that stuff with me, and he really doesn't. So, thanks, Frank. Thanks, Frank, for calling him out, though.
Oh, I wasn't calling him out. I didn't know if you guys had seen it
No.
or not because it was sent to me at 1 o'clock this morning. That's how I knew about it.
Yeah. No.
And I went to bed at 10 o'clock and laid there and stared at the ceiling until 3:30. Didn't shut my eyes one time. I was so hyped to get downtown and get down there, and it wasn't shit. I was like, oh my God, we're going to have to sit through and listen to them talk about the shit they filed already.
Well, now I just want to hear the juice on Weber, this conversation.
All right.
Okay.
Everybody knows about the talk that's been going around about the garage, right?
Yeah.
Kay is debunking the whole thing about the garage.
Okay.
She's debunking it,
She
saying
did that a long time ago.
Yes, 3-car garage. There's no sinks, no nothing in the garage. There is a water spigot inside the garage. There is no way for a motorcycle to fit wherever she was talking about to get a tire print, and I don't know if I should take that as vetted or look into it even deeper.
I don't think that, in my personal opinion, that theory does not make
It doesn't make any
damn
sense.
lick of sense.
Thank you. I've
No.
said that all along.
And everybody questions me about it. I'm like, look, I'm not talking about it. I'm not able to vet it, so I'm not going to talk about it.
Yeah.
And let's say the part where Kay is debunking it, let's say that is vetted and that's true. I want everybody to think back about all the things they've heard from people and think back about when people have talked about personally talking to Kay and getting that information.
Give me a
And
second
then
here, and I'll get the
evaluate your
messages.
sources.
I'll get the messages and I'll send them over to you guys, and you can pull them up. Give me a second.
Okay.
But let's not show them because they're not ours to show.
Okay, no problem.
Yeah, I mean, you can just read it if you want without showing it.
Let me find it.
Well, what it says is, this may all be true, but not happening at the Weber's garage. My garage has 3 bays in front and 1 in the back door. The back door exits onto a deck. One could not drive a motorcycle to the door. My garage does not have plumbing. It does have a standard garden hose stub near the first bay, about 3 feet inside the garage. There's no basin or faucet area to clean up with.
Right. Yep. Same messages I got.
But my question is, and I hope I don't offend anybody with this, but in what world does the killer, we'll say Richard Allen, but
Come back on a
Richard
motorcycle.
Allen go gets the girls on the bridge, takes them across the creek to where they were killed, goes back across the creek to Weber's. No, wait, goes home. No, wait, hold on. Let me go back. Goes across the street, goes to Kay's, tries to clean up, goes home, gets his motorcycle, comes back to clean up the mess he made from going across the creek 5 billion times. Like, what world?
Always searchers are there.
Yes. That's crazy.
And see, I still believe the timeline's off too. That's just my opinion, and I'll tell you why. If you go through the index pages, we all know, we've discussed it, that some stuff was left out intentionally. Dave McCain, what time was he at the north end of the bridge? We never got a clarification of that, because that's got to be added in the timeline. What time did Cheyenne actually get there at the trails? Because that's got to be added into the timeline.
And those things will be once the trial comes, but they weren't, they didn't put them in the PCA, but that doesn't mean they didn't happen, of course.
Right.
I'm not going to put everything in the PCA. And, I think, Sonny, one of the reasons I didn't send, that message to you is because neither of us had really taken that serious because of, kind of like Ivy just said. Yeah. Because you would have had to cross the creek, I'm like.
It didn't make sense at all. And so we had talked about it a couple times about this whole garage thing and whatever, but It just never.
I've never
made
given
sense.
much credence to it.
No.
Yeah,
no.
I've had so many people question me about it. I said, look, yeah, I've talked to quite a few people about it, but it hasn't been vetted, so I'm not comfortable about talking about it.
And it's part of and the whole thing. The reason it came back up is because people have said it's part of the index things that have came out, but we can't trust those index things are authentic or real.
And it's not even in there, is it? Like when you look at them, yes,
I think there's a part that says Weber's garage, isn't there?
I can't remember, but it does mention Richard Allen's motorcycle in
But
there.
that's all. It doesn't mention. I mean, that's a big leap between a motorcycle cover and that theory.
Absolutely.
I just want this case to get to the point where we can actually hear all the evidence that they have.
And isn't it funny when it comes to the Weber property, how, we heard through Julie Melvin's talk before about how that, Kay has said that they focused in the bathroom of the house. It started out as the house, that the investigators focused a lot of their time in the bathroom of the house, looking in the drains of the shower and sink.
Yep.
And so, once, that kind of like people were like, okay, well, there's nothing really to prove that or back it up. Then it changed to the garage. Then when, like it was said, it wasn't the garage, then it changed to an outbuilding. And so now that it's been, considered an outbuilding, it's still this whole faucet area, the drain. But none of that, none of that has been substantiated at all or ever been given any credence or validity. And in fact, Kay Weber herself has said it's not true.
Did she deny her either garage or outhouse or whatever? Did she deny that those were searched at all?
No, her property was searched, but her property search, I don't think it was searched 6 times like people are alleging. But she volunteered for them to come on, like she had no problem with them coming on. There was never a search warrant, even for the Weber property, because she gave them access.
Right.
I just remember that guy, I can't remember his name, who had a family member who had access to information and talked to Gray and knew he had information from the beginning, but it was right. All of it was right. And one of the things he said was something about Weber's garage getting searched several times. But besides that, again,
there was something when they searched their. I think what Kay said was that when they looked in the garage, Brad Weber had collected animal bones. Why he did that, I don't know.
I kind of like bones. I'm not going to lie.
They did find that they were initially suspicious, mainly because of the proximity of the home, and they did find some blood at one point in one of the outbuildings or garages, but that it was deemed to be animal blood, and they never even, they also took Brad Weber's 6-hour and kept it for 6 to 8 months while they compared it to the bullet they had. It turned out not to be a match.
Well, let me ask you this.
Okay.
Do you believe there was a picture of him on trail cam?
Of the BG?
Yes.
No.
The reason why I'm asking, because we'll go back to the Julie interview with Kay. Kay allegedly said that the FBI, when they went down to Arizona and interviewed her and Mr. Sanders, that they showed her a picture and asked her who it was. And she said, I don't know who that is, because he's covered from the nose down. Now, where did that picture come from?
I've heard that too, Frank, but I don't know.
I think my memory may be failing me, but I remember a story of her being showed a picture, but it was a sketch. So could it have been that a sketch was shown?
Yeah, it might have been, but it's always been said it was a picture. So that's why I was just questioning it, if anybody knew anything about it.
Well, remember, a sketch is not a photo.
If you're going to listen to Doug Carter.
Right.
So do you guys all believe that BG was caught on a cam at some point?
Well, I think he was caught on a lot of cams. I don't know about a trail cam.
When you say you think he was caught in a lot of cams, can you?
Property cams.
Well, I'm more talking about like the different cams that are.
I mean more once they I feel like, they had the Hoosier Harvest Store camera. I feel like, but I feel like once they came to Rochelle, and I feel like they probably went back through all of their surveillance video footage around town and probably have his movements much more narrowed down.
What about the mirrors?
That's what I meant caught on camera. As far as like walking across the bridge, I don't mean they were like
the mayor's house does have a camera on it. But there has
The
been
barn.
right. There's been suggestions that he possibly went across the field behind the Mears property to keep from being seen. So,
because I tend to think, and this is just from the information I have, I tend to think that he was not seen, like his car may have been seen on the Harvest store, but he wasn't seen, like his body wasn't seen, which would mean that he somehow went around that in order to be seen on 300 down the road a little bit, walking back.
So why would he be walking right? Like, meaning, so was he caught at all walking back, or do you think he went back behind?
I don't think he's on camera walking back.
I see the problem that I see with that whole situation is that we don't know exactly where she saw him on 300. We don't know if it was past the Mears property, if it was down by the Harvester store, or where it was at.
Right.
Yeah.
We just know when she passed the Harvest store, because her car is on the Harvest store footage.
Right.
So she may have seen him closer to the CPS building, and then half a second later she passed the Harvest store, and so that's the timestamp we have.
Yeah, I think she saw him between the time after he would be out of frame that somebody, what am I trying to say? The furthest towards the CPS that the Harvest store can't see, between that point and the CPS building. I think she saw him somewhere in there. So somehow he evaded that camera, but then ended up on 300.
Right, and it all depends on where he came out of the woods at. If he came out at the cemetery, it would have been very hard for him to miss that camera.
I think I've always thought, and maybe it's because I haven't been there personally, so I don't know. Everybody says you have to kind of go to really understand, but I thought he went through the woods like parallel to the trail, and yes, you can see people, but if you're not looking for somebody, then if somebody doesn't see you, are you seen?
Well, from my experience being out there 7 times in 2 years, my first time went out there, it was me, Randy, support with Steph, Marv, and all of us, and we were all at the crime scene. So me, Randy, Betty Noor from Michigan, all walked up the ravine to the cemetery, right? Well, support didn't want to go that way, so she decided to walk the trail. Well, when we got out on 300, walking back toward the drop-off point where the girls were dropped off at, you could see Steffa walking through the trail all the way to the Mears drop-off point. There's no foliage or anything.
But
that doesn't mean the Harvest store camera would have picked it up.
Right.
And if somebody was on the trail, if they weren't looking for somebody or thinking, can I see somebody in these trees, would they have noticed somebody?
You got a point there. I mean, I would have to assume you would have to be looking that way to notice if anybody's walking that way. I mean, if you're just walking straight and somebody's in the woods, you're not going to know it unless you're actually looking over there, And get to the question, Brown Skittle. From my understanding, Cabe flew back immediately to question Brad.
Oh, yeah, there's that story too.
Brown Skittle also said, didn't Holman say something about a trail cam at CrimeCon? I myself don't recall. Did he? Anybody remember?
Mm-mm.
Okay. Yeah, I'd have to go back and listen, to be honest, on that. Frank, do you believe that simply Richard Allen will be found guilty?
Yes.
Mm-hmm. I do too.
Honestly, I do. Just from his admissions alone of being out there and then changing his timeline. I mean, that was the dumbest shit that he could have ever done, was change the timeline in that memorandum. I mean, 1 minute you're saying you're there from 1:30 to 3:30, then you're turning around saying 12:30 to 1:30. Well, that's a complete lie, because the girls saw you at the Freedom Bridge, hightailing it toward the Moon on High Bridge between 1:30 and 1:45.
Mm-hmm.
And that's from Riley said that.
Do you think that the timeline was changed? And this is just going through my head right now. Do you think the timeline has changed because in the discovery that they have, say, video footage of seeing his car at only the one point and not the both points? And that's kind of where, and they'll probably play like that those witnesses, can't remember crap because one's saying this color, that color, this. Anyways, do you think that that's kind of where that timeline came from? Because if they're looking at the footage, they only saw it and they deemed him as leaving at 1:30 instead of getting there at 1:30.
Well, I have to look at it just from what really Voorhees said. She said that she was walking back toward the Freedom Bridge because she had to be home by 2:00, and that's when she passed him. And he was walking toward the Monon High Bridge. So right there is telling you that they're trying to change the timeline.
Yeah. I mean, I personally think that RA will be found guilty at the end of the day. Like, that's just my own personal gut feeling. That yes, he is the guy that's on the bridge.
I mean, just from the 3 or 4 times that I've actually been in court and he's been there, the last time on October 31st, I sat right on the aisle intentionally, directly behind Kathy. And when they brought him in, he stopped, turned around, and said hi to Kathy and his mother. And then when he was up at the defense table, the judge was directly talking to him, and he was answering. And I swear to God, I heard BG. I mean, he sounded exactly like him.
Yeah,
I mean, it might be my brain playing tricks with me because we've been hearing the same thing over and over for years. You know what I mean?
Yeah. I'm confused though, like with Kathy. Like, so I feel like, so if he's confessed to the mother and Kathy multiple times, and then she's going to court, standing by her husband, do you think that Rosie and Baldwin basically said, well, look, he only did this because she seems very gullible to me, Kathy. She sounds like she's that person that is follows her heart type of thing. I think she seems very sweet and kind. And I can almost see Rosie and Baldwin being like, no. He did this because he was scared, so he had to confess because these Odin, correctional officers or whatever are basically.
The thing with Kathy is just from my experiences with her 3 times being in the courtroom and sitting directly behind her, it almost made me feel like that she was the man in the family.
Oh, really?
Yes. Oh, yeah. She'd turn around and give us all snarl looks. And Julie, she really pissed me off back in June. She sat right next to me, and Kathy sat directly in front of her. And them two were just holding conversations like they were best friends. And then Julie leaned over to me and said, they're going to let him go today. And I looked at her and said, what the hell is your problem, Julie? I said, whose side are you on? And I cut ties with her that day. I've talked to her since.
Yeah. I don't have anything to do with her personally. I don't respect her myself, but that's my own personal preference about her. She doesn't really come into my brain thoughts, to be honest with you. Besides, go ahead.
Oh, no, I'm sorry.
Yeah, Ivy, you are correct. Rosie is death penalty certified. He's one of, I believe, 3 in the state that are certified.
I found a list, and I can't find Rosie or Baldwin or Scrimmin or Librato on any of them. So maybe it's not updated. That's the only thing I could think.
Yeah, I thought that one of them was death penalty certified.
Yeah,
I think Rosie. It was Rosie, I believe.
Yeah.
I put the list on the tab.
And Sonny, I sent you an article, and I'm a little bit more confused now with this new filing today after reading this article, because the way that Fox 59 presents the new charges, they present them as additional charges, which technically they're saying now means that Rich Allen's charged with 4 counts of murder.
Yeah, it's always 2. It's always double. If you got 2 homicides, they're going to charge you with 4 counts of murder.
Right. And so I'm saying, so they didn't override the previous charges. They just added them to it. So now he's charged with felony murder and regular murder plus kidnapping.
So it's almost like he's saying that this is our only guy we've got.
Yeah.
That's what it sounds like to me.
They're saying it's 4 counts of murder.
And see, I talked to Vito, and I said, I need to talk to you and Holman after this is over with. He said, all right. just meet us outside. Well, he said, man, we've got to go be with the families. Can you call us at the office? And I said, yeah, I'll call you guys on Monday. Because I want to find out the situation with Nick, this crap with him pulling in court, said, well, I believe there could be other actors. Well, I need to know if there's other actors or not so we could put that shit to rest.
Well, I think this is putting it to rest.
I feel like it is too. Okay, well, Adam, do you want to quickly read the article? Or
Yeah, I mean, I can read it real quick.
Okay.
Let me pull it back up. Sorry. This
It's
is
just a short one.
on the same day of the Indiana Supreme Court heard arguments about whether or not Richard Allen's original defense team could be reinstated on the Delphi murder case. Carroll County prosecutor Nick McClelland filed new felony charges against Allen. Allen was previously charged with 2 counts of murder in October 2022 after being accused of killing Abby Williams and Libby German on the Monon Heights Bridge in Delphi in February 2017. On Thursday, McClelland filed additional charges against Allen more than 1 year after his arrest. Allen now faces a total of 4 counts of murder and 2 felony counts of kidnapping. According to the new filing, McClelland argues that the previously released investigative findings include cause that Allen kidnapped Abby and Libby by force prior to their murders near the Monon High Bridge. Due to Allen committing the act or attempting to commit the act of kidnapping during the alleged murder, Allen can now also be charged with 2 counts of felony murder, where murder is committed Allen can be charged with 2 counts of felony murder, where murder is committed during the act of another crime. McClelland stated these new amended charges more accurately aligned with the charging information leveled against Allen in the high-profile murder case. Allen's legal team has been notified of the new charges leveled against their client. Allen remains in the midst of a battle with Judge Fran Gull over his defense team. However, as Gull previously removed Allen's original attorneys, Bradley Rossi and Andrew J. Baldwin, after she found them grossly negligent in the wake of evidence leak. On Thursday, the attorneys representing Allen argued before the Indiana Supreme Court that Rosie and Baldwin's reinstatement. Allen has previously pushed for a speedy trial in the case, which is currently set to begin in October. It is unclear if the new charges will affect the proposed trial date or a potential Indiana Supreme Court decision will once again shake up the docket.
And see, that does bring me back to the hearing that I think about it. How, oh shit.
Do you have a brain fart again, Frank?
God, there was so much shit today, man. It's just like trying to remember everything.
I know. I get it. Brain mush. Brain overload.
Rescue was sitting there jotting all the notes while I was listening because I was going to be trying to be sneaky. Okay. I had my phone, my StreamYard running, right? And so I turned the camera off so you couldn't see anything in the courtroom, but I left the mic on intentionally so everybody could hear what was going on in the courtroom. And then all of a sudden, Vito looked over at me and I said, nope, I can't do this. I said, I'm not doing that with him sitting right here. And then my phone starts ringing in the courtroom.
Oh, Frank.
It out of nowhere. I had it muted and everything, and it just started ringing. I was like, everybody just looked at me. I was like, oh, fuck.
Because it was your messenger, wasn't it?
Something went off. I was like, I got it on mute. I don't know why it went off like that.
Yeah, I'm sure it was your messenger that probably did it.
It was like, geez.
Yeah. Because that's happened to me before where I've had it all muted and then my messenger goes off and it's like, what the hell? I had everything turned off.
And then when it happened, Tara looked right down at me and I just kind of turned my head a little bit like it wasn't me.
Yeah. It was MS.
It wasn't me. It's that bailiff up there.
Okay.
Here's
So-
my
Go ahead.
can I
Ann.
tell my conspiracy theory.
Your
I'm sure it
conspiracy
probably won't
theory?
happen. Here's my conspiracy theory.
Okay.
Let's say that Rosie is not death penalty certified and that the list I looked at was up to date and neither Rosie or Baldwin is death penalty certified. What if they heard the arguments today and they were like, oh shit, we're not winning this, they're coming back, so let's death penalty it, so we'll have, even if they're reinstated, we'll have to get new attorneys who are death penalty certified. That's my conspiracy theory.
Is that it? So is Rosie or Baldwin death penalty certified?
I've always heard one
I'm
of them
not
was
seeing their names anywhere here.
not on there. Yeah.
Right. I mean, it would say it. They would be on the list.
So I don't know.
Hold on a second.
So is Scremin or Librato death penalty certified?
Nope.
I wouldn't think Librato would be because he had that little misconduct thing he had.
Okay. So, Adam, quickly explain this whole 4 counts thing.
Well, I can't. I'm not sure. You know, I'm just was relating what Fox 59 is reporting. And Fox 59 is saying that, you know, these are 2 additional charges, which means he now has 4 counts of murder against him and 2 kidnapping.
It does say on there, in addition to, like they're going to add additional charges. However, we have talked about like how bad they are grammatically. So it wouldn't surprise me if that's a typo, but then it also wouldn't surprise me.
But then someone was sending me an example of, they said the same thing happened in the Shenandoah case, which I'm trying to think of what case that was, but they said it ended up because there were 2 victims, but they still ended up being 4 counts of capital murder charges. So I'm not sure how that happened, how you can charge someone for murder twice on the same victim.
I thought if there was twice, you couldn't, they could be convicted of both of them. It was kind of like a lesser charge that you could, like, we don't think that we can convict him on regular murder, but
you can bring him up against both. So maybe that's what they're doing. They're you know, they feel confident they can get the stronger one, but in case they can't, they're keeping the weaker one there too.
Right. So when they get to the jury, it's just like, how do you rule on this?
Or maybe it's just worded badly. I don't know. On my case, it's not. The charges aren't updated yet. It still only has felony murder.
Right.
Yeah. That'll be interesting to see.
That's a motion, isn't it? So the judge has to rule on it. Is that right? Or can they do that by themselves?
Yeah, I mean, I don't think any judge is going to, you know, rule against, like, you know, the charging. Well, I don't actually know. I think the charges can be brought. I think the charges are the charges. So I think the charges can be brought by the prosecution.
Yeah. I was just wondering from like a standpoint of updating the, you know, like the record so we can see exactly what's there.
Charmaine, ask defense attorneys Ali or Bob about this.
They filed a leave motion too.
What's that?
Motion for leave to amend filed.
That's the one that
that's what we're reading.
Okay.
That's what we were reading earlier.
Let me look up at the charging information to see if they've changed it yet.
And the other one, the other new thing that was on Mikey's stage just says new. Or on Doc's pop at least. It just says new.
Yeah. Okay. Do you want me to bring that back up, actually? We never did read it.
There we go. Nope, they still got him under the 2 murder. That's it.
Yeah, it'll take them.
Well, whoops. Close off this thing here. I still want to read this because we haven't read it yet.
Real quick before you, Aspen, on my case, it says on the thing you were talking about where it says new information, it says amended pleading. And now I can't remember, amended pleading filed, I think. So maybe they want him to like agree to amend his innocence or his not guilty pleading to the new charges. Maybe.
Right. Yeah, I was looking at the Docs Pop thing. I said one of them just says new, and then the other one says motion for leave to file amended charges.
Well, the new information says amended plea something.
Okay, so
it says amended plea filed today, and then also motion for leave to amend filed.
Yeah, they've updated it because when it first came out, it just said information new.
That's what it says under the amended plea.
Is those things on Doc Pops the same thing?
Yes.
Yeah.
Okay.
Well, there's 2 filings. We just haven't got the second
filings,
one.
But yeah.
Yeah, and Carroll County Clerk's Office doesn't have the second one for whatever it is.
Yeah, it just says motion for leave to file amended charges PDF. It isn't a PDF. You got the PDF already, so.
Yeah. Well,
let's read it because there's a part in here that I have a question about. So
Yeah. I'm going to send Sunny what it said. Just like I said, they must have updated it because when it first came out, this is all it said.
What?
I didn't mean to call you, Aspen. I just wanted to pull this up so I could see it.
Yeah, I see that, Adam. Why'd you send that to me? Adam?
He's gone.
Oh, we look like, hey, hi. I hate it when we go in this angle. But okay, we'll go like that. Just looking at my three chins there for a second. So do we have to ask Faith for the other one?
Let's read Deb's comment real quick. She says the fact that an attorney's name is absent from the death penalty qualified list does not mean the attorney is unqualified under trial rule 24.
Thank you, Deb. Sorry, Frank tried to call me and it kicked my audio out, guys.
Yeah, you said it was an accident on there. So my question goes back to still, do we need to ask Faith for the amended copy?
What time is it? Let me call her real quick. Give me a second.
Okay.
All right.
Okay. Thank you. All right.
She said she would send me anything else that came out today, and I didn't get anything new. But let's see what she says to Frank.
Yeah. Okay. So Charmaine says, "Well, no need to ask. That's what it means. If we think about it, all the hub was that they only had to prove he forced the girls down the hill. The action ended in the girls being murdered, felony. Now the state is saying not only did he do that, resulting in their deaths, but they intended to also prove he ended their lives. But I can ask if you like. So hence why there's 4. Is it right? Am I correct, Adam? 4 murder charges? And
That's
2
what Fox 59 said.
Right. But isn't what Charmaine's saying 2 and 2? 2 murders, 2 felonies, 2 kidnapping? Because
I'm saying Fox 59 is saying there's 4 counts of
4
murder
and 2
counts. Yeah.
Yeah. Ask, what did the fox say? Dun, 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 dun.
That is how.
And that could be maybe they are doing this so that if it comes down to a plea, they can have him plead to felony as opposed to regular murder to take the DP off the table. That could be a bargaining tool.
Oh, say that one more time, Adam. I was just texting my husband.
I said, maybe they've amended they've added these charges on there so that if it came down to a plea negotiation, they could then go with the lower sentence, which would be the felony, and that would take off the DP. They could use that as a bargaining chip.
Oh, okay. Gotcha.
Right. That's what I said. It was like regular murder. I don't know what you call it.
Yeah, regular murder. I'll be right back. I just have to go use the washroom, so just give me a minute. So you and Ivy talked amongst yourselves. Go ahead.
Oh, I thought you meant Frank and Ivy. Am I alone up here?
No, because Frank's on mute talking to Faith.
Oh, that's right. So Ivy, Ivy, how long do you think it's going to take for them to issue some sort of decision on today?
I don't think it'll be very long. I don't really know what the typical time is, but
a few weeks, basically.
A few weeks. Okay. Well, Kara said that they are the most efficient in the country. So I don't know, a week and a half.
Yeah. And I mean, clearly, getting everything back on track, I think is a priority for the justices. So
I'll have that leave here in a second, guys.
Okay. My biggest question right now, say that they are going to come back on, they're reinstated. What happens to the rescheduled trial by the attorneys who were there in between? Because
I assume they just remove that.
Get them on track. If the Supreme Court is remedying a situation to fix a problem, then is it fair to keep the rescheduled trial that is charged to the defense? That's a product issue that they're remedying, if that makes sense.
No, it does. I think that, I think a new trial, I think there'd have to be a hearing to set a new trial date. But I think that would also be dependent then on them filing for the, 70 days thing.
See, that they brought that up in the hearing today, where that the state allegedly saying that they had filled the paperwork out for the
But they never
speedy
filed
trial,
it.
but they never filed it. So that's on them.
Yeah.
That's not on the court. You can't
I thought
hold
they
the
couldn't
court.
file it until first.
No,
They said they were going to file it on the 1st. There was no reason they couldn't have filed it before that.
But for what I'm talking about, though, I was under the impression that once you charge that time to the defense, up until whatever the date is that the trial's scheduled, you can't file a speedy trial.
According to
That's what
Indiana
the charge
law,
is.
from what I've read, it says that in Indiana they have 100 days from the time he's either arraigned or arrested to file for the speedy trial. And that's what he was allegedly going to do for the January trial that originally was supposed to happen. It was going to be a speedy trial. And then all this mess came about.
But neither of those were 100 days from when he was first arraigned or arrested.
Nope.
So I'll have to go look. I didn't think you had to do it in the first 100.
I didn't think so either, but I don't know. I thought they could do it at any point.
That was my understanding, but like once the defense made a continuance or whatever to schedule it in the future, then from that day to the date in the future it was scheduled, they couldn't file a speedy. It had to be after that date. Therefore,
then I'm not sure, Ivy. And I don't know if that would just be negated by the fact that, if the new attorneys are just dismissed. I don't know how that all works. That's why I was like, wouldn't it be interesting if they made all 4 of them be his representation?
Can you imagine?
Well, I mean, maybe they wouldn't do so bad together. I mean, the only filing we've seen from the new attorneys seem to show that some of their interests are aligned in the same feelings that the ex-defense had. So maybe the 4 of them would work as a good team.
And hopefully, like, no matter what you thought of, another attorney, you'd be able to work with them and, for your client. But I guess I'm going off of one of Kara's tweets said that the current attorneys weren't talking to her or her partner and had told them that they believe they were not working in the interest of Richard Allen, basically.
Oh, I know what you're talking about. Yeah. I mean, that's not going to be a court decision. That's just her opinion.
And like I said before, it was all, you can't blame the court because they asked for continuance from the original trial date.
Right.
So
the original trial date was supposed to be March of 2023.
Right.
If anyone remembers.
So why is it they're asking for a speedy trial when they never filed for one from the get-go? It's like they're blaming the court for them not being able to file it. That's what it seems like to me.
Right. To me, it's just null and void. I mean, they can file for a speedy trial like anytime they want. So, I mean, if they get reinstated, they can file for a speedy trial immediately.
Well, I think Nick's going to be ready for it anyway. I think he's expecting to be a speedy trial.
I've seen no evidence that the prosecution is not ready to go to trial. I know people have argued that. I've seen not one bit of anything that even points towards that. And Charmaine, there was a court filing on October 10th or October, I think it was October 10th, stating that all of the discovery had been turned over before the November 1st filing.
GP says Indiana is just a murder charge, not felony. Never heard of that one.
Well, exactly, Charmaine. No discovery. The discovery had. I think the first time I remember seeing a discovery mentioned as being turned over was February 13th. I'm sure they'd gotten some prior to that, but I wasn't saying that I expected them to go to court in March. I was just saying that was the original court date.
Well, we know when Richard got the damning goods. We know that. When he started
April
getting the paperwork, he got the goods, letting him know, hey, we got you, buddy.
About the murder charges, Indiana doesn't have like murder 1, murder 2,
They don't.
all that stuff. But there are the two, like there's murder, and then there's what most people call felony murder. It's just the like number 2 version of murder. But it's the like murder. How do they word that? Somebody killed in the commission of a felony.
Yeah.
Which is what he was originally charged for. And then the amended includes the regular murder. So there are 2 different kinds.
Yes.
Just reading the chat.
Did you talk to Faith, Frank?
Let me check my emails. They were supposed to send it to me.
Yeah, I think that the... Oh, who's calling me?
Come on,
Somebody's-
Renee. Damn. I sent it to Faith.
Someone hit the call button in the crime chat, in our crime chat, Adam.
Come on, Faith. It don't take you that damn long.
It was Lewis. I know sometimes when she's tardy, it's just like,
And
Faith?
she's usually right on it.
Yeah.
She's right on it usually.
When it takes longer, I'm just like, tap, tap. Come on, Faith. I know you're really fast.
But I heard Brandy in the background telling me I have to send Faith an email.
Oh, okay. Oh,
What about Faith?
Brandy, I heard her in the back. I was on the phone with Renee, and I heard Brandy in the background say, "Tell Frank he's got to email Faith."
Yeah, no, I've talked to Faith, and she said she was going to send me anything else that came out, and she just said, "This is the new one. I have it."
Okay.
Oh, you do have it?
I'll send it to Sunny real quick.
Okay.
Yeah, I haven't got it yet. She's probably going down the list of her emails.
Pretty much.
Yep.
I didn't send one.
That's what Faith told me one time. She said, instead of you just sending an email anytime that we get anything, we got a list of people's emails we're going to send it to.
Because there's what'd you say, Ivy?
They should just do a big group one.
Miami County does the same thing.
Yeah.
Or even better, they just put it on my case. So you can just click it.
I know. That would be
PDF format. Yeah, I think that's a lot easier that way. Instead of getting bombarded by emails or phone calls every day, just PDF it and let us pull it right off my case.
I don't understand it.
Me neither. I'm just waiting for Adam to send it still. Frank will have his by then, Adam.
Nope, not yet.
No, I sent it, Sonny.
I don't see it.
It's 9 pages.
What?
Is it? Did you put it in?
Christ.
I'm sending it to your messenger. It's still sent. It should be sent now.
Okay, I just got it now. Okay.
Send it over this way, Aspen, if you don't mind.
Oh yeah, no problem.
Yeah. Okay, you're gonna send it to him, Adam? Okay.
Yeah.
Okay, so let's bring this down. Stop screen. We'll bring up.
You just had it up there, Sonny, I think.
No, I had the old one up. This is 9 pages, Adam said. I just need to share it here and make it bigger. Okay. Whoops, that's too big. That's too small.
Information new.
I know, that's what I was like. It's called information new.
Yeah.
What the hell?
Hold on. Is that?
Oh, they're throwing all kinds of statutes in here now.
Every time you say that, Aspen, my brain automatically pictures like McClellan saying, "We've been new," and then sending him the paper.
Boss.
Okay. Let's see. Adam, do you want to start reading it or whatever, or what?
Well, if I kept it open. Actually, I'm gonna run to the restroom. I'm gonna let you read it while I do that.
Okay, so let's see here. I'll start off. Or Ivy, do you want to
I'll
read some?
it.
Yeah.
Oh,
Sure.
that is different.
All right, let's see. Count 1, murder, a felony. Nick C. McClellan, being first duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen did kill another human being, to wit, victim 1, while committing or attempting to commit kidnapping. So that's the felony. All of which is contrary to the form of the statute in such cases made and provided, to wit, with the number, and against the peace and dignity of the state of Indiana. I affirm under the penalty of perjury, as specified in the law, that the foregoing representations are true. I lost my spot.
Then they got the witness list.
I saw the witness list the other day, and there's some names on there I don't even recognize.
Who's Clinton?
That's what I'm saying. I didn't recognize that name. I could tell you from Dan Doolin down are all law enforcement. That's all I know. And Kathy Allen, Betsy, and Sarah Carball. Those are the only names I know on there.
And then RV, that's Voorhees.
Yeah, Raleigh. Yeah.
Brad
Weber.
Yeah.
Terry Wilson. Interesting.
Okay, so count 2. Go ahead, Ivy.
Count 2 is the same thing that I just read, except for victim 2.
Oh, except for what?
Except for victim 2 instead of victim 1.
Oh, gotcha. Okay. Witness list again. Count
3 is murder, a felony. Nicholas C. McClellan, being first duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen did knowingly or intentionally kill another human being, to wit, victim 1. Everything else is the same, just the different numbers.
Yeah.
And then I'm assuming the next one will be the same, but victim 2. Yeah, so far we've got, like Aspen was saying, we've got 2 felony murder charges and 2 regular murder charges.
Okay. And then count 5.
5 is a level 3 felony. Nicholas C. McClellan, being first duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen, while armed with a deadly weapon, to wit, handgun, did knowingly or intentionally remove victim 1 by fraud, enticement, force, or threat of force from one place, to wit, the Monon High Bridge, to another place, to wit, a wooded area. That is a little more detailed than we had last time, I believe.
Yeah.
Same, the bottom's the same.
It's going to be obviously the same, yeah.
Yeah. I wonder if the witness lists are the same on all of them. Let's count how many witnesses there are.
There's 13, I think. 13 to 15. I counted them the other day.
Who's Brian Harshman? Let's see.
2, 4, 6, 8, 10, 12. There's about 18 there.
There's people that I've never.
Yeah, that's what I was saying. The Matthew Clemens. I don't know who that. Jeremy Clinton. Josh Edwards.
21, it looks like.
And there's people in this list that weren't on the list above, I don't think.
Well, some of these names weren't even on the one from the the file dump from back in February.
9, 10, 11, 12, 13, 14, 15. There's 16 here. There's 21 when you go further down.
Can you put that in the chat, the file?
Yeah. 1 sec here.
So I can compare.
My bad.
There's a lot of them on that one that I don't recognize.
Are you talking about putting it in a crime and shame chat?
Wherever, just so I can click on it.
You know what's funny about this list? You don't see Dave McCain on there. You don't see Derek German on there.
I think it's because any person in the story that we know, after they were abducted, I don't think they include any of them.
BW is Bree Wilbur.
Oh, okay.
And that's another that situation with her has really got me wondering what is really going on with her, because you know how Keegan gets arrested for the CSAM when he comes back from Vegas, right?
Mm-hmm.
And then what is it, like a week or so later, U.S. Marshals pick up Bree Wilbur to question her about the Anthony Shots account?
Oh, sorry, Frank. I didn't hear what you said.
I wasn't aware of that.
Say that
Yeah.
again, Frank. Say that
Where
one more
you
time.
got, if you go back to the index pages, it'll have Bree Weber when she was interviewed by U.S. Marshals, and it was like a week after Keegan got arrested when he got back from Vegas. Why'd they wait so long to pick her up and talk to her? We all know that she was out at the trails that day.
Right.
So why'd they wait so long?
Why did they wait so long to arrest Richard Allen?
Well, I mean, I've got my opinions on that. I mean,
Yeah.
I'm just going to tell you, I feel like they were on to him at the second presser in 2019. That's just my opinion.
Yeah.
But
Yeah,
wouldn't
hard-
that mean they were lying in court documents when they say that they came across whatever and gave that story?
You're going to have to explain a little more so I understand what you're saying.
I think in one of the affidavits it said that somebody came across a tip, blah blah blah, in one of the affidavits that they would have had to sign and say that was true. I mean, I guess they could have like worded it in a way where that could be true, but it also could be true that they were on to him.
I mean, when I look at law enforcement or attorneys, they use that lingo that none of us understand.
Yeah.
So it's really hard to try to understand what law enforcement are saying in these documents and attorneys, and unless you're really well equipped about law and things like that, you're not going to understand a damn thing they're saying. And that's why I take the time for myself when I get these documents. I'll proofread them, and I'll look for key words in these documents, and I'll take that key word and I'll go research it and see how it's being used in this document so I can get a better understanding what they're trying to say in these documents.
Yeah, you have to.
So
I will say I don't believe the Whiteman thing. I don't think that was a problem, because even if you titled his tip, put it under the name John Doe, even then they still have a tip that there's like anybody who doesn't even have training would have went back and investigated. You just wouldn't have known the right name that it matched up to, but you still would have known that there was a guy on the bridge at the same time who we haven't talked to.
Mhm. Agreed.
Oh, Sharon, that's a good question. I haven't looked at them all yet, but I haven't noticed any of them being on there.
So does anybody know anything about who the CI is? Adam?
CI, what does CI stand for?
Confidential informant.
Okay, I wasn't sure what that meant, but exactly.
I keep getting one name thrown at me, but like I said, I don't put names or anything out there unless I can vet it, and I can't vet this.
Right. I've heard that as things as well with that same. I'm sure it's the same thing you've heard, because it really all comes from the same people. And so, yeah.
Okay, let me ask you guys this. Do any of you believe that Keegan's tied in any way, indirectly or directly?
God, Frank.
Well, indirectly. That's what I think.
But I think
Indirectly.
but I think indirectly could just be the fact that he was, committing a separate crime on, sadly, possibly trying to catfish these girls. But I don't think he had any involvement whatsoever in the actual murders.
But see, the only problem that I have with this whole situation with the Anthony Schatz and Keegan Klein, it's like me. I've had my Facebook hacked, okay? When somebody is trying to log into your own personal social media account, you'll get a notification that somebody's trying to log into your account.
Right.
So if somebody else had access to that Anthony Schatz account, Keegan knew about it. He had to have.
Plus, IP addresses don't lie.
You know what I mean?
So even if someone else had been using that, the IP address came from that house.
Right.
Mm-hmm.
I mean, he even admitted that he let his friends use his phones.
Yeah. I mean, honestly, I've been wrong on so many things. I don't even know anymore because my gut would always say that Kagan was indirectly involved in a sense, like meaning I don't believe he partook in the murders. I don't whatever, but I feel like there's some attachment somewhere
Right.
to Kagan Klein.
That's how I feel.
You know, but and then again, you know, so let's say this, okay? So if they bring back Rosie and Baldwin, okay, and then they ask for a speedy trial, whatever, we're gonna hear this shit a lot sooner than waiting another freaking 8-9 months, whatever it is, till October. You know, blah 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 blah, and then there could be more delays. So, what do you think about that? Because it's one of those things that's like, if they're brought back on, we're going to be knowing, you know, this is going to go to trial a lot faster, and then we're going to like know this stuff. I mean, at the end of the day, you know, regardless if it's Librato or Scremin or Baldwin or Rosie, it really still ends up being that the evidence, however it gets presented to the jury, is that the jury decides his guilt or innocence based on this evidence, regardless which lawyers are there. Well, I mean, obviously, two lawyers are going to handle it maybe two different ways. From the look of it, it seemed like Librato and Scremin were going to go almost that same route with the whole Odinism thing and whatever. And I'm sure Rosie and that would be more than willing to hand over every freaking file that they had to them. But anyways, what do you think about that? Because if they are brought back on, then we should see this trial date start a lot sooner.
Unless Nick decides to continue it.
Hey, yeah.
Because honestly, when he made that statement in court about he believes there could be other actors involved, I mean, this is a ploy to drag this out. That's how I looked at it. I'm like, this dude's want more time to gather more evidence. That's why he said that. That's how I felt about it. I'm like, why would he do that in the middle of court? And 6 months later, we're not hearing shit about another accomplice or an actor. Or was he asking for more time, basically, a roundabout way?
That's why my question about like how the speedy trial would work, that's why I'm asking that question, because if they, and again, I could be wrong, but if how I understand it is right, then if they come back, the other attorneys made it where they can't file a speedy trial until like November or whenever.
October,
would
yeah.
Take back, or like how would that work?
See, I'm not up to date on when it comes to the speedy trial stuff.
Well, in what way, Frank?
I mean, I know from what I've read that you're supposed to file for speedy trial either within so many days of your arraignment or your arrest. But what happens after that, I don't have no clue.
Yeah, I get it. Same.
I have no clue. I mean, I don't know if the clock stops when somebody files a continuance on the speedy trial date or how it works. I don't know if the clock starts over, if it stops, or what happens.
Yeah, right, and that's where maybe Travis could have answered that for us, unless there's some almost lawyers in here besides Adam that know the answer, unless Adam does. But yeah, because I remember looking it up too about the speedy trial, and you get the gist of it. But
right, and you're trying like, what does this mean?
Well, that's me all the time.
I'm like, what does that mean?
So yeah, we need a lawyer. We need another lawyer. Travis, get back in. Mind you, he wants to do a live tonight, but I'm sure we'll find out the answer before then, perhaps. I mean, I haven't ruled that out yet, Chris. He could be letting his lawyers run with the theory, see where it goes. He could still take a plea deal once this SC makes its decision. So what happens with that? If they make the plea deal, let's say there was a plea deal made, is the discovery then sealed, or will it be available to the public at any point?
You could do a FOIA request once it's all like said and done
Once
with.
the case is set and done with, yeah.
But I think to me, a plea deal would be really contingent on what he was willing to talk about
or divulge. Right.
Like I mean, I know that for the family, they just want answers.
Yeah.
And I think to save them the heartache of going to trial, a plea deal with him actually saying exactly why he did it and what he did would probably be the best case scenario.
Yeah.
But that's only if Richard Allen is guilty, which
Well, we're just going to call him guilty in our court. Yeah, our court of law. We're just going to say that. Hypothetically speaking.
And for Frank.
What?
Sir. So Ruckus, he's like adamant that this is going to end in a plea by Allen. Do you know if that's just based on the motorcycle theory, or is there anything else that opinion's based on?
I would think you would have to add in the fact that his two statements he made, one to Doolin and the second interview he did when he was picked up and questioned before he was arrested, the bullet, him admitting to wearing the same kind of clothes, being at the bridge at a certain time. I think all that is enough to get a guilty plea. That's just my opinion.
And maybe that shows a pattern of him being willing to admit things.
Right. I think the pressure's getting so hard on him right now. Just my opinion, like I said, the pressure's on him so hard right now. I have a feeling he's going to end up changing his plea.
If I'm not mistaken, I think a long time ago I said that probably will turn out to be a plea, but that was just, now that I think about that. Yeah, I wouldn't surprise me, but then I keep seeing this side that Rosie and Baldwin, if they get put back on, like they really want to play out this whole Odinism thing. I don't know.
I mean, in the memorandum, it was blatantly obvious what they were trying to do. Richard Allen brought up the Odinist crap intentionally. Yeah. It was blatantly obvious.
Oh, I mean, and this whole that he was so scared that he confessed bullshit. That's just. Go ahead.
To me, there's another question though. Is yes, they use the Odinist in the Franks, so that would be to like get the search warrant thrown out, and then for the safekeeping to move him. But if they make it to trial, is that the defense they're going to use? They may use something completely different.
Mm-hmm.
I mean, think about this. Of all the experts have been interviewed over the last 3 or 4 months with regards to this Odinist crap, how many of them have agreed that this crime scene was set up as a Odinist whatever?
Yeah,
everybody's
I agree with
against
that.
it.
The problem is, though, that you're not, let's see, those experts aren't making the decision. They're not convicting or acquitting.
Right.
It's regular people, and satanic panic is a real thing. So a lot of people believe that rituals of killing kids is going on all the time.
Yeah.
You can give them evidence. They do not believe it.
Yeah, I mean, for me living here in Indiana, I have never heard in my 54 years of life of a person being ritually sacrificed. Never.
You've never heard of a real one, but have you ever heard people talk about them?
Oh, that's right.
Well, I mean, yeah, back in the old ancient days.
No, I mean like people now saying that there's satanic ritual, like, yeah.
A lot of cases, when it more comes to the conspiracy theorists, a lot of cases, their whole cult thing was involved in the killings and whatever is like pretty much out there all the time. A lot, really. A lot.
And I'm not saying that happened. I don't think that happened. I'm saying that it wouldn't be that crazy statistically to get one person on the jury who believes that.
Right. Gotcha. Well,
so I mean, does anybody believe that Richard Allen tried to set this up to make it look like Odinism? I mean, think about it. We know what they've taken
No,
from the home in the search warrant. Magazines, books. What are them
I
books all
don't.
about? Was
But I don't.
he into that crap, or was he learning about it, or you know what I
I
mean?
I think that that is a possibility, and I do myself kind of feel like he was like that to distract from the truth. He was trying to make it look like it was some sort of weird ritual
Mm-hmm.
thing, like not that it was Odinism, but just that it was some. Without say, I think him even having a brain cell to know how to do it. I think he was trying to portray the crime scene to look like it was some sort of ritualistic thing going on because those sticks are set purposely. They're not thrown on the girls. They are set distinctively purposely of how they're laid out, but not that it tied in to Odinism as much
Right.
as portrayal of a ritual.
I watched Court TV last week and had Bob Mata, MS, and a couple
Yeah.
other people on there, and even had a person who practices
Yes, I
for
remember
it,
that one.
and she blatantly said, "No, this has nothing to do with it. It doesn't even look like it."
Mhm.
So
I tend to I agree a lot with Sonny, but I tend to think that the reason he put the sticks there, I don't think it was like trying to make it look like a ritual. I tend to lean more to it was more of a compulsion on his part, and there's other meanings in them. Like I tend to look at Abby and how differently they were both treated.
Right treated.
I think there's a lot into that. And if you look at like the way the sticks were placed, there's two big ones, not I guess they're not both big, but there's two of them covering the neck injuries or the throat injuries. So like is that him covering those up? And then there's the other one there for some reason. So when we look at it, because again, even people who don't believe it can still get sucked into like there's got to be like a bigger thing to this. Maybe he was just feeling guilty and it was something about covering those up.
yeah, like Mustang said, staged to look like something that it's not.
Yeah, like whether it was to be ritualistic or just simply that they were just placed there because in his brain he just kind of randomly just positioned them. Like, well, I wouldn't say it was random. The sticks here, I would say that
But
that
there was
was,
like a meaning to him of
you
some
know,
sort.
say it again.
But there was like, are you saying that there was like a meaning to him that maybe not
Right.
ritualistic,
Well,
but in his brain?
it's kind of I feel like it was kind of one of those things like where somebody's going, well, let me just put a stick here and stick here and a stick here. And, I feel like there was meaning about why those sticks were both across each of the necks, in a sense to
Right.
cover.
And remember, a ritual can be individualistic as far as it could be specific to the person committing the ritual. Doesn't mean it has to be like an Odinism thing or something like that. It can just literally be, a ritual to that one person.
Right.
Can I get to this question by Chris Owens?
Sure.
It says, when did his parents live? Talking about Richard Allen lived near the Kleins. It wasn't Richard Allen's parents that lived near the Kleins. It was Kathy Allen's parents that lived near the Kleins on 2nd Avenue in Peru. And they lived a 10-minute walk from each other.
Okay.
On the same street.
It's okay.
Yeah. It was Kathy's mom who lived there on the same street.
Hmm.
I just don't think, I know a lot of people put meaning into that, but like, I don't know, maybe I'm just a weirdo. I don't know anybody I live by. I don't talk to them. Like, I might wave at them, but like, I couldn't tell you who lives 5 houses down.
Are you a hermit?
Maybe.
I'm not going to lie, I am.
I'm with you.
I to be these days.
I don't know my neighbors. Not more than just to say hi.
Yeah, I probably wouldn't recognize them in Walmart at all.
Well, but in a place like Peru,
I live in a small town. I'm from a small
I've
town.
lived in small towns as well, and well, let me think. Like when I lived in 15,000, and how many is in Peru now? I don't even know. But back in the time when
12,000.
but back in the time when I guess maybe they would have known each other would have been a lot less. So I don't know. I think it goes both ways, because I know when I lived in Whitecourt, everyone freaking knew everybody.
Oh yeah, I think it goes both ways. I just mean that it's not. Some people look at it and they're like, "Oh, well, they had to have known each other." I just think that it's still possible they didn't.
Right. Well, I
possible.
agree.
It's
I would
possible.
have to agree with that. Just
There's a
because
lot
they
of-
lived on the same street doesn't mean they knew each other.
Right.
I
And
do
you can-
agree.
There
Like, I assume everyone knows me, but I don't know them. I'm kidding.
There's a weird thing in small towns too, where you know of people and you might even know like who they're related to and stuff about them, but you don't know what they look like because you just know of them because of small town stuff, but you've never maybe met them face to face or enough to recognize them later.
Can I give you an example? So when Richard Allen was first arrested, so I was talking to a local of Peru, and they were like, it was like day one, they told me they were like, they didn't know Richard Allen, but they knew of Marvin because everyone in town apparently referred to him as the Tesla guy, because Teslas aren't super common in Peru, and Marvin Allen owns a Tesla. So that's an example of like what Ivy was talking about. So even if you don't know someone, you know things about them. So everyone knew Marvin Allen as the guy that owned the Tesla.
Yeah, that's a perfect example. Or
Yeah, it's
maybe
basically saying I might not know the person as a person personally, but you know of them.
Right.
Mm-hmm.
He's the Tesla guy.
Right.
Now I want to go back to, I can't remember who said it, if it was Ben or somebody said it. What about that so-called interview at AutoZone?
Again, it's a rumor. It's not in any factual documented information that I've seen. But I've heard the rumor, of course.
What, the interview at AutoZone?
Yeah.
Yes, it's from the index.
Yes, it is. But
But that
see, we
doesn't-
don't know if that index is correct because we know it's
Right.
been altered. We know
Right.
that.
Right. So it's just speculation.
Exactly. And we're not going to get the discovery. I doubt even if there is a conviction, we'll ever get they'll release the discovery on it.
Well, no. As soon as the case is over, you can request it, just like people did with the Keegan Klein case file.
Well, yeah, I get that, but it doesn't necessarily mean they're going to give it to you.
Well, they have very little legal grounds to stand on when it comes to a closed case, as far as not because of FOIA requests.
Right. I was going to say that.
When a case is open, it's a whole different thing. But
What
once
about
a case
children?
is closed, it's very difficult for them to not give you the files.
Oh, I'm having a hell of a time right now with Wabash City Police Department because I spoke to the city attorney and he sent me a document with my name on it and everything I had to sign to get the file.
That's in Canada.
And it's been 2 months.
Right. Is that for an open case, though?
Yes.
Yeah. So when it's a closed case, it's a whole different thing.
Well, he told me the reasoning is I haven't got it yet. Is when the chief sent the file over to him, they didn't redact anything out of it. So he had to send it back over to them to redact it. Now they're telling me I've got to drive 2 hours to go get it.
Okay.
I'm like,
yeah, they don't
file
have to
the
make it
damn
easy.
thing.
Yeah, they don't have to make it easy, but
No, they're not. Believe me.
Yeah.
So, Aspen, hypothetically, after this case is over and you can get a FOIA, can they make it where like you have to come pick it up in person? Because that's an issue I've had following on an Indiana case because I live in Oklahoma. Like, how I can't come pick it up.
well, like one of the things, like even like in like this, I live in Mecklenburg County in North Carolina, which is which is the biggest city in the state of North Carolina is Charlotte, where I live, and in order to even get court documents or even filings, you can't get them online. You have to go in person to the clerk's office and get them. So they're available, but you can't get them online or over the phone. You have to go in person. So like even though it's only 1.5 miles away from me, like if I want a document, I have to go in person, and that's for anything.
See, I really wish somebody would sue places like that. I wish it would go to the Supreme Court so that there would be precedents, because to me, that's getting around the, what is it called? Not the letter of the law, but the what of the law? The spirit of the law. It's getting around the spirit of the law because they know most people can't do that. Because not only do you have to live there, you have to have a job that will let you off during the day, during hours. You have to have transportation. And then a lot of times they charge you, like if you get $1 a page, most people
Well,
can't afford a case file.
yeah, and that'll be the other thing is when this case file finally is available, you'll have it'll you won't it won't by like we can call like the county clerk's office in Carroll County and be like, hey, now that the case is over, we want the file. Most likely you'll have to request a FOIA request and you'll have to pay for it.
Yeah.
I tried to get the Tablets of Chuck Raines file from Hamilton County here in Indiana. The trial for one of the girls that was charged in that case was a 2-week trial. Guess how much it was going to cost me just to get the transcripts for that?
$500.
Try thousands.
All right, there you go.
$12,000 for a 2-week trial transcript.
Because they let them charge, or at least in Indiana, they let them charge up to $1 a page. So that's what they all do. But
Right.
think about that. That is copying or printing out one sheet of paper that they're charging you $1 for. That's crazy.
Yeah, and yes, Daniel K. to that.
I haven't heard that case, but I will look it up.
You know, the docket. I mean, how much? Adam, remember there was that file, and I think he said he paid $100 and something for it.
$87 or something for it.
They
Which I was surprised it was that, because that was the whole Epstein file. I was surprised it was that.
Yeah, it was the Epstein file.
Are you
was like
talking about the people's names?
Yeah, the docket. We were talking to him the other night, and he requested the Epstein file, which was like 13,000 pages. And I was actually surprised it only cost $187 or whatever it was.
Yeah, it was like 100 and something, I think he said.
Because some of them
That's
are,
like 50 cents a page.
Right. But if you remember, remember when there was that content creator, Zav girl, that got
oh God, yes.
For putting the Patreon Gannon Stouch pictures out.
Yeah.
She got that from the FOIA request because after the conviction, she was able to request the case files, and they were in those. The autopsy photos were included in the case file.
Because it's from Florida, yeah.
And each state's a little different as far as what they automatically will include in it.
And yeah, you know, I mean, I remember when crime scene, the courtroom there, John, and
he just got all the Lucy Leppy files. Sorry, Sonny.
Yeah, well, I remember when he was showing me the price of what the Lucy Leppy was, and it was like $11,000 or something like that. It was somewhere around there.
Did he pay that?
No.
Sorry, and that's the UK, everyone, but
yeah, that's UK. But nobody was showing me how much it was.
But he got them all though.
Did he get them?
He did a thing where he got all of the maybe it was just the court file, maybe it was just the court transcripts. I can't remember, but he made a post about it just yesterday or the day before. And then he's going to be doing a whole bunch of live or videos on it.
Videos on it.
Hey, listen, guys, I ain't been to sleep.
Yeah,
no, it's okay.
I'm
getting hungry. Yeah. No, Frank, thank you so much for joining us. I totally appreciate you coming on, bud.
No problem. Not at all.
Thank you. You go have a good sleep or something. Get some food.
Well, everybody's want me to go live tonight, so I've got to get a little bit of sleep. I stayed up all night last night.
Yeah.
Laid in bed about 10 o'clock and just stared at the ceiling like, man, this is going to suck because I am not going to be able to sleep. Ready to go. I was just ready to go. So, but I appreciate you guys having me on tonight. So,
we appreciate it.
Love you guys. Take care.
Love you too. Bye, Frank.
Bye.
That's been great. Thank you to Travis as well. Whoops. So now we're 3. We're going to have to change that up so we don't see our 5 chins there.
I wish we could delete that option, Sonny.
I know. Well, it just automatically does it when somebody leaves.
That's why I was like, can we delete that option?
Yeah.
One more thing about the paying for stuff real quick. You know Zav Girl, that big to-do about Gannon Stouch and the pictures of his autopsy. I don't know if you guys heard about that.
Sonny, Ivy, were you not just listening?
You wasn't listening.
No, was I not listening? No. I had to
That's what about Zav Girl. That's what we
I just
talked
talked all about that.
I missed that part. What did you guys decide about it?
And so Danielle K, she says, I think that's why the docket gets so upset when people take his stuff. I know him and Plunder going on documents and other case file stuff because it is so expensive, like thousands of dollars. You know what? I think because I seen a post that he ranted on the other day, but I think it's one of those things like Docket puts out a lot of filings, right? All the time on different cases. I think it's a fact that when, like, meaning everyone has the ability to figure out how to get filings, how to get court records. And some people I think are just plain ass lazy and just expect him to get the stuff or whatever and stuff like that. Because he does share, but and again, I think it's tomorrow. Is it tomorrow, Friday? Like, he helped me out when I asked him if he had a certain file, which was on the Carnes case, that Travis knew the judge. Remember that you guys, this case where the judge and his wife their lives were taken, murdered by the son. And so I'd asked the docket if he had by chance any filing on that, and then he helped me out. So I will buy him a couple of coffees on his Twitter.
And we shared his thing the other.
Oh yeah,
the other night as well.
Yeah, like I didn't ask him to do it. I just, like he could have easily said no. Very kind, but I think it's more to do with like the people that just have an expectation of him. And it's like, people, like, you can figure out how to get these documents and that yourself. So I think, because you can tell the docket is a very kind and generous person.
Yeah.
But to the point that when people start taking advantage or have this expectation, so I remember sending him a tweet going with that phone emoji from Bitmoji or whatever, with the cell phone going.
He was in our chat the other night. Speaking of, when is the docket going to join us?
Well, he said not till after the Triconis case. And that Triconis case is like, he went live on that. So if anyone's not watching that, again, then docket's covering that case if anyone's interested. And if anyone doesn't know what his YouTube channel is, it is called The Docket. And I've said this before. And I want to say, and Kathy is a great lady. She came into our Canadian live. And whenever I've gone on to The Docket in his channel, both Kathy and The Docket are have very kind words to talk about us. But anyway, so I want to say that I truly appreciate The Docket, because if anyone's here is not, if you guys have Twitter and you guys want to know about some of the cases that are out there, again, just look down the docket's Twitter, and he'll have a lot of different motions happening for This is the link for his channel here on YouTube. Like, so again, he covers a lot of cases now. Before it seemed like he was doing like a lot of Twitter stuff, but not as much on the channel. But now I see him covering it, because why not, right? I mean, he's gathering the information. Might as well do the lives on it as well. And on Twitter, I'm just going to grab it because, again, this is a very useful tool for all you sleuths that follow certain channels. And when I say sleuths, I'm not talking about just creators. I'm talking about the ones that are in the true crime field that like to follow certain cases. So if you're not following him on Twitter, I'm going to drop the Twitter. Okay. Honestly, I recommend that you guys go, if you're on Twitter, absolutely follow The Docket. If you're not, on Twitter, go watch his channel, or perhaps consider getting Twitter, because again, there's so many cases, and all day long he's like filing for different cases that come up. And I want to say, I personally appreciate that, because I remember when I was having a conversation quickly with Docket, and this one guy, this reporter guy, he only put a piece of an affidavit, just a little piece of it. It's like, dude, if you're going to show that, why don't you just attach the actual affidavit? Like, why just a piece? And I remember the Docket saying, like, this is kind of exactly why I do what I do, meaning, hence, like, here's the full document, not just a little cut-shaped blurb, but here you go, here's document. And so, so if you're on his channel or tweeting and you're getting a bunch of information to him, and they do pay a lot. Paula from plunder as well. They put tons of money out for this, money that I don't personally have, not even close to what these people want for these documents that they're always putting out. So like I said, I'll buy him a couple coffees and that tomorrow to thank him for helping me out. But people should be very generous in giving back, because they do cost a lot of money. And a lot of this information you wouldn't have if it was not for people like the docket. So, and so anyways, I want to say again, thank you to Docket. Thank you to Kathy as well. Her name is Mama Bear, her little icon there. And I'm just very appreciative of that type of information. The first go-to is pretty much, did I pop out and pop in? The go-to that I typically go to on Twitter is, hey, does the docket have this? Which his name is Eric, by the way.
The docket is such a great name.
Oh, absolutely. The docket. I know, right? And the other thing that always sticks in my head, the docket, and then aficionados, when people use the word aficionados. But anyways, Adam, Travis.
Hungry.
I know. Travis was talking about doing it live again tonight. Did you want to do a live again tonight?
Well, I think it was someone else was talking about, if you guys could explain these charges. So, it's all been a little jumbled. We've been on for 6 hours.
Yeah.
And, I even I have so many thoughts on the Kagan Klein, all of those things. But it's I was so focused on the Supreme Court stuff today that I can't even begin to think about all of this other stuff like Weber Garage, So to isolate the new charges and maybe do a stream later tonight on them, I think could be good, because I think we've said a lot of information about it today, and I think a lot of it
just
is
to compact it a bit for people.
But just to have it be a specific topic, I think is going to be a lot more easy to digest, because most people aren't going to go through a 6-hour live and pick out those pieces that we
exactly.
So doing an hour and a half on those tonight, I think could be beneficial.
Yeah.
And we may have time to look up some of those people on the witness list.
So I was reaching out while we were talking. My camera's off, so I was reaching out to a couple people that that I talk to all the time, and I seem to be in the minority of being like, are there names on here we don't recognize? Because the other people that I usually talk to, I said, no, I think I recognize all of them, but I said I would look more in depth into them later. Because I have a list. I was going to say of who the witnesses were. I have to find it now, and what position they held.
Yeah. Because remember, there was a list a long time ago.
Yeah.
Well, there was the Keegan Klein list, and I went through and figured out who each person was.
But in one of the charging documents, there's a list like these were, so we should just be able to line them up and see if there's anybody new.
Well, there was also a list at a different point that was in one of. It was in the. Do you remember when that whole 184-page thing came out? That was mostly redundant stuff. I think there was a witness list in there, or there was at one point there was a witness list released. I can't remember what it was, but a lot of people talked about how, because I've said all along Brittany Allen's going to be on the witness list. She has not been listed on a witness list so far, but the prosecution or the defense has to release their whole witness list right away. In fact, we've gotten no inclination to who the defense witnesses are.
Yeah, these witnesses are who is included in the probable cause of these charges, right?
Right, but there are names that aren't in the probable cause, and a lot of them are marshals or investigators or people like that.
Okay, let's wrap this up. And Chris Owens, it says if Libby was targeted by them, maybe they chose her as their next victim, or maybe she knew secrets about them or something. Honestly, your guess is as good as anybody else's of the answer to that $1 million question about who, what was the reason for it, and stuff like that. We don't know if it was truly against Libby, Abby, what the whole thing was. That's really the $1 million question, really, on that. But anyways, thank you guys for joining us. Thank you, Travis. Thank you, Frank. Thank you, Aspen. Thank you, Ivy. We will come back tonight. So if Ivy wants to come on or Charmaine wants to come on, and feel free. As we talk about it, it's totally up to you guys. Let me know. Thanks, Ben. You love your wrench now, don't you, Ben? Don't you? You know you do. Anyways, thank you, mods, of course, for reminding people about likes and stuff like that, and just being. Thank you guys all. I love it. I love it when it's a very respectful chat that goes on in here. Everyone's just voicing their thoughts and different things and stuff like that. I'm glad that we're really a drama-free channel of all that crap, that we just kind of can have nice conversations. Anyways, so before we get going, is there anything else Adam or Ivy need to say?
Nope.
You guys good? I'm hungry.
No, the only thing I'll say is that I think that, I think that what we saw in the Supreme Court this morning, I think was a very, very positive example of 5 justices that have the best interest of the victims and this case moving forward at their heart. And I applaud what I took away from that as being a sense of not being biased one way or another. And that really just looking at the facts and asking good questions of both sides. And
Totally
I think it's going to go a long way in negating any bias that people accuse the court of having, regardless of their decision.
Well, and correct me if I'm wrong here. I think this really boils down to, were Richard Allen's rights violated by the Sixth Amendment of him, wanting to have his attorneys, or that, maybe that Frangel didn't do as well that they said. But that seemed to be like a big thing. Like, are you comparing wheat to, the Sixth Amendment and da-da-da-da-da-da-da? Am I wrong in that? Because that's what it seems a lot to boil down to for Richard Allen's part of it, about the attorneys, about the Sixth Amendment right, and that, were her. Go ahead, Ivy.
I just said I would agree.
Yeah, on there. Anyways, Ivy, if you want to join us tonight, feel free. Let me know. If you guys want to look into those names and stuff like that, to know who those people are, and I'll, like I said, do up a thumbnail, do up a link, send it to Travis and whatever. So yeah. So, and if Charmaine wants to join, it's up to you. Did you want to come on later, Ivy, or are you not sure yet?
What time do you think it'll be?
It will probably be the same time that we typically do.
I always forget what that is. Is that?
Well, I don't know, Adam. What time would you like to do it? Because you're
normal time, if that's okay.
You want to do it at 7?
Yeah.
10 o'clock Eastern Standard.
It's already because it's already 4 o'clock our time, and like I
should be able to do that. I have to work at 5:30, but I should be good and done by that time.
Okay. Alrighty. Okay, guys. Well, thank you guys again very much. And we'll see you tonight on the live as well. You guys take care. Have a great one. And thank you guys so much. And thanks, Deb, for the super chat earlier. Love you. Miss you. Too bad you're babysitting, but I know that you love your grandbabies just as much. Anyways, take care, guys. Bye. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all